I'm sorry, are you guys still waiting for Punjabi? It's in Manchester. It's back.
Oh, yeah.
Okay,
About 8, bit off the road.
Was that all because you have that?
Yeah, they were really early today.
Yeah.
They rocked up yesterday about 8 and there was no one here. Dead. But yeah, got here. Well, my colleague got here about 10 minutes before me and she said, oh my god, it's already full up, I can't get in. So we just started last night. But yeah, everyone's super keen today, I don't know why. Because nothing's going to happen. It's just the end of the case, but there's no verdict or anything. Maybe less other things to do today.
So we just had two. We just had Q and ODS.
Is that it?
Yeah.
ISTW?
No, sorry, NSTW. So it's 914 and 903. I'll see if we put you here so we can see all the... Maybe we do that. Yeah, sure. What do you think? We just put you here and be like... Another day.
How's it going?
Getting there.
Down yesterday.
Yeah. I think that's cold today.
Yeah, isn't it? Yeah.
That was a bit rude.
Can't we get every day?
No, can't, not every day. At least it's not raining.
Yeah, I think that's coming on the weekend.
Yeah. So we're after 45.
Boo.
It's going to be this one this time around.
in London on ETX1. Good mate, how are you doing today? Thank you, mate. You'll pass something for you first. Legendary.
Real find a way to win at home for sure. It'd be pretty cool. So Arsenal can make it to the final.
Yeah.
It just always managed to.
Yeah, I know,
They always
yeah.
look
Against
like
the odds.
the worst team on the pitch, yet
Yeah.
still managed to grind out a win.
Villa should be quite good tonight against PSG.
Mm.
PSG.
Yes, they do.
Boston as well.
I never really seen much of Villa because always focusing on London games. So yeah, it'll be interesting to see the games.
Yeah, I think they could give PSG quite a good game. Barcelona as well.
And then Bayern Inter. Don't know who will win out of that.
Hey mate. How are you? Yeah, good. Cheers for sticking around, yesterday. Sorry about that. Well, yeah, that's true. It's just know that at least one of us is ready for even video games.
I think they're pretty happy.
Well, they want Harry turned up a court with video games. Also,
Exactly.
let's take a look at this wonderful, wonderful Metro front page this morning, which involves this lovely picture of Harry there, as we can see. I think that's one of ours. And a screenshot of the YouTube stream, which is their live court proceedings, aren't they? So that is
Wasn't that on the inside?
it's contempt, isn't it? Whoopsie.
Well, I think it's also contempt for us to be sticking our cameras through the fence here as well.
Everyone does that.
It's all.
Yeah, safety
Nancy.
numbers, everyone. Come on. No, that's pretty brazen. And that's just great. I mean, that.
Cameras in court.
Cameras in court is different. So cameras in court you can't see him. So this is from the cameras in court is just on the judges. So someone put a screenshot of the YouTube channel, and the YouTube channel carries a very clear. This is a live broadcast. Same rules about contempt apply.
I was trying to listen to it. Sorry, yesterday.
No. Yeah, really does. It's good for about half an hour when they start and they say this case is about blah 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 blah, and then they go into and then they always say, right, I'll just turn to the case law and the authorities on this, and then you just go and then you just put your pen there if you just think you're on the next
Switch off.
useless to them.
I saw.
Oh, and in this case, the judge saying
Well, we don't get anything today, do we? Closed door.
we're getting like an hour in open, and then
I thought the whole thing was
no, not all
from
of it.
10:30.
No, it's up from like 11:30 to like half 3. I think they said, but they're running behind on time. So that's what the judge said.
We'll have to wrap it up today. There's no excuses. Job done.
That's basically what he said. He said, figure it out so you don't feel hard done by. Yeah, boss isn't the kind of judge that sit late. And yeah, people are like, well, this is what you were allocated. You fucked around, so it's up to you. Voss is quite a judge. He's the judge who did the ruling on us being able to name judges in the Cyrus Reeve case. You know about that? So you know Cyrus Reeve? So a family court judge. She was involved in family court for years before she died. Basically, actually, it was from within 2 weeks before she was born. The council said we have concerns about the care of this child. And 3 different judges were involved across 10 years. And, the family court judge here said, no, you can't name them. Even though no one had asked for that. No one had asked for them to be anonymised, and judges are always named. And so we appealed it, and the court of appeal went, yeah, that's about right. The boss basically said this judge did not have the authority to do it. Good man.
I'm just trying to work this out.
About 9:30.
Yes.
I think it'd be about the same stuff. Do an hour of break. There you go.
I'm going to go. How have you done?
No, I've got to try and
I can move this.
get it through.
Yeah, I'm going to try.
I had to borrow a screwdriver from you guys down here to get the to unscrew everything. Can't stick my camera through.
Yeah, because there's a little bit wide. An A7S would be great.
Okay. I thought about it, but
Right, it's the problem, it's putting the camera within the corporal room, so
Everyone's
doing it.
I was just good for Preston.
Yeah.
Past 10, I'm going to the Met Police we can use it. No,
You want to put in the car, go get worse.
latent consistency.
Because we're quite old actually here, so actually down there is almost
It's about that little kid.
Hopefully my colleague is over there.
there's another one.
No.
Notting Hill, isn't there?
Oh yeah, there was, but they're not
It's not
related. I mean, fortunately, they're not related. We did ask, but fortunately, apparently, every lad.
Yeah.
Well, I'm not sure whether it's better or worse than our parents or something.
Well, that's true.
But I suppose at least they found them up.
Oh, it's the one from 20 years ago.
No, that was delivered.
Yeah,
She got a suspension sentence. Fair enough. No, it's 3 babies, all from the same parents. Abandoned over 7
Today he'll
years.
probably sleep properly because nothing really discussed.
Yeah, I think he'll do his little bit under the clothes bit and then he'll be out.
Kids are alright,
Expensive.
but at least all of them survived. Yeah. No, I mean they were left in like cold temperatures. They were all discovered. I think they were okay, but I think they said it was so cold when they discovered the first and the third one. Couldn't take her temperature for like 3 hours. She was that cold. It's in family court. Well, they haven't arrested. They can't find it. They're still trying to find the parents.
Is that what the briefing's about?
Yeah. They're doing like house to house. They're quite clever. They were telling us how they've narrowed it down. It's like 300-400 houses. I think it could be. Using like geography experts, demographic experts, and all that stuff. So
We were allowed in to film it literally 5 minutes ago. Like, it was just everyone on Zoom. And then they're right now for the actual ourselves.
yeah. Sounds like it's helpful, isn't it? Yeah. No, they've been good for this. That's hard to really prove.
Modern life.
Oh, briefings this afternoon. It's I've got a judgment to do at 10:30. Lucky enough. Pleased to be back. What do you think of the weather, man? What do you think of the weather, Simon? Ready for the lights? Arms for the poor. I don't think they're going to be telling any of us off in that way. I don't think you're going to get arrested for contempt of court.
Say that.
The Ministry of Justice have just put an email out saying the use of YouTube still is God, that's funny.
Apparently I'll get done for that.
Apparently the judge has been briefed on it. So, probably. Yeah, it's fine. It's fucking
Can
horrendous.
I just hear
And then they're putting their copy of the first photograph in court. And I'm like, yeah. I wonder, he's the first person to be photographed in court, I think.
I thought maybe when you were showing us.
And are you
Fucking idiot. No. Just fucking idiots, I'm afraid. Oh well.
I saw you turn, that's why I looked at my phone and I was like, not looking at the camera.
There's no actual listeners.
Do we get royalties for that?
Well, that does beg the question of what he needs to be reading. He's not giving evidence. So.
They stayed on a bit last night.
Where were you? Where were you yesterday morning? Were you at another job?
I was like, they put Brady on 7, put me on a 10. So I was like, why have you done that? Sometimes like...
I did listen to you when I rang you up. You were like, yeah, I'm not there yet. And I thought, Lucy's, yeah.
I messaged you, but like 7 being like, still down for you, where are you? And I'm like, what?
Who messaged you that, Brady?
Yeah. Like, I'm not until 10. And they're like, it's fine.
Oh, wait.
Oh, wait.
What happened to Ruby then? Where's she today?
No, that's lost. She said she was just here to have a cover.
What's that mean?
Yeah.
Still, nice girl.
Yeah, it's really nice. She's
Boo! Not really. Which one did you go to? The big one? Yeah. Oh, yeah. Do you get to come back in like coffees on expenses?
Yeah, a couple. That's good. Not
Well, we've got a little kitchenette in our press room, so we don't really need to buy coffees anymore. We used to, but now we couldn't play with that. Sadly.
where you get some chill.
Yeah.
Just
Oh, fucking.
in case you wanted to get a nice.
Yeah, God. Birch. I'll take a picture of the phone for the family to prove that I do actually have a job.
So, yeah, minute ago, someone went to school with, he stopped me and went, should we go to school together? And I was like, yes, we did.
What do they do? Oh, well, you're doing better. See? See? Every cloud north. Every cloud north.
I was saying today, right, I've got no makeup on, I've had like 3 hours sleep, my hair's been done like,
What have you had 3 hours sleep for?
can't sleep. It's stupid.
Yeah, mate, loves it. As your brain goes, I didn't do very well with the crossword today. I normally do much better, I just couldn't get into it today.
I find crosswords a lot harder.
And they do, yeah. Prize draw slip. Something ticking. Raffle ticking. Perseverance. Perseverance.
What do you mean? I chose it for you.
Relating to sight. Oh. Optic. 20 peak apex. Second, let's see. Yeah, I thought it might be humble, yeah.
Engraved in it pen.
Yeah. Yeah, sometimes it's problematic. It's sometimes problematic. The lack of security guards is...
They all went down to open the gate.
Oh, okay.
So I was encouraged to do that.
Maybe he's not coming today.
Go for that.
Imagine.
It's fresh, but then even on the tube I was still sweating.
Yeah.
So then I did go on the Victoria line, and that's, like just going into a sauna for 10 minutes, so maybe that's where I went wrong. I quite like the old cool breeze. Well, yeah, you guys did.
I've never worn gloves in my life.
Necessary?
Only use it like 2 gloves.
It's good to have.
Yeah.
Good to have. You can always take them off.
I've done this during the summer.
Did you ever meet Kendall? Kendall was like yay tall, not far in girl from Texas. She just used to always win that type of stuff.
Oh, really?
Yeah. She was nice, I see. I like Kendall. Her visa expired.
Oh, really?
Yeah. Too much watching my laptop. No.
Photographers waiting queues and arrival queuing is there to last 2 days. And part of today's session, if you go to those tours, it's going to start discussing those security arrangements. So this sensitive information. 3 judges are here to discuss what's doing the judges.
job not so long ago with FIFA, and the woman from FIFA, we're in the St Pancras Hotel. She put her laptop down on the floor just like that, and we were all sort of stepped into the room, and we're focusing on what we're doing there. We just weren't really thinking about anything else on the floor. Turned around when we finished, and she said, "Did someone take my laptop?" We looked at each other, no. And some guy had we went down to the front desk, we looked at the security footage. Some guy had just walked up, saw the laptop, walked down the hallway, come back, stood there for a minute, saw that we weren't doing anything, picked it up, just walked out.
Yeah.
Fuck, man, he's so graceful.
Yeah. We had someone brought in with a kit next.
So much stuff gets stolen these days, it's really not.
Oh, it's not really a lot else.
There's nothing to do.
Gotta go to
No. Loads there was, I think it was Jeffers. Someone broke into their office in Barcelona and stole everything. Fleeced the entire office. And other people I know elsewhere around Europe. Someone in Zurich was there. He was out for a job in Zurich, and they stuff in there. Lens has been stolen. It's a big problem everywhere. Apparently before the Rio Olympics, I didn't go. One of my colleagues went though, and they said they couldn't get insurance because it's technology is like the number one stolen thing in Brazil. And they said they just couldn't get insurance. No one would insure it. Everywhere they went, they were so definitely paranoid. People were going to steal their stuff.
My dad didn't go to the Olympics when he went to the World Cup. So the hotel they stayed at wasn't even like particularly fancy. It's like why the opposite of God.
I worry about it quite a lot when I'm doing jobs these days. You know, when you're doing a protest or something, there's so many frustrating things around you.
And you put it down without kind of thinking.
Yeah. Or you've got a headache, or you're trying to grab someone for a box pop or something. You can't even move a metre away from it. Have someone trying to pinch it. Here we go. Team yesterday, isn't it?
Oh, look. Oh, yeah, no bother. Oh, fucking hell.
No, they've just unlocked it going, you know. Well, they all their what's it in it. They normally come out. That's what he's good, isn't it? Look at that.
Very good. Camera off.
Carry it around.
Absolutely. I have enough here in the note. No plan of open justice. How much did you want to hit?
I'm really jealous.
My pen was. That's what he's wearing, so that's all I need to put in.
The suit.
That's yeah, dark suit.
What was you wearing yesterday?
Loosely. Got a patterned tie.
Same suit, different tie.
Oh well. Tabloids and love that.
They were, yeah.
It's the same suit. Wear like a nice summery number.
The colder ones. Puffy jacket.
Yeah, better. Canada Goose.
Yeah, more Stone Island. Get a badge.
10 out of 10 placement. Bash. Harry waved to reporters and said, "Get the badge in," as he walked to the Supreme Court of Justice on Wednesday. So, could you imagine?
I paid to
Yeah. Hands out flyers. My wife's I ran half marathon last night, and mate, honestly, I really hurt. My back hurts, my knee hurts. He says triumphantly, he's 24, 26. Yeah, I might need that desk back without. Once I go, it's like, come out. But then I wouldn't like that's normal TV right. Yeah, people just stay in the room and get up short or something.
Can you work out whether they're there? Yeah.
He's at that level with his head.
No, I know.
I would say probably
I'm surprised it came as early as it did yesterday. Yeah. They're right here on
Blatant contempt of law.
Yeah. Moving things on the court status.
Touching stuff.
Don't touch anything. Press can't touch anything. press can touch the press bench.
That was a heritage listed sign, that one.
Oh, Prince Harry. So again, not as far as we're aware. There's the other one. Done them before. The foreign Dubai. It's a slightly bizarre experience. Dubai was doing that. He went to give an opening speech at Paul. I've just got this job and I'd asked for more money. It's a sweet it was cool. It was quite busy. It was cool. I wouldn't particularly take it to Dubai. No. It's very. How was the cheese last night? Oh yes, how was it? It's a shame it was after.
The first free kick was brilliant. And then I think it was all of them. Exactly. And I just went over and that's great. The second one I thought was easy.
Was it a red card? And Declan Rice is going, that's definitely.
In the 94th minute.
When you're losing 3-0.
Yeah. And just kind of how you expect. And you might be I don't think it's right now.
No. But don't. Especially when you're losing 3-0.
And he goes shit. He had that joy.
That's what you can do, is just put some lift to follow that shot, I guess. So what he said was essentially in the second half. Oh, okay. So, yeah, see, that's, I always think it's good, so if you get, because I don't like my friend when you say it's a sweat, you care about it's league.
Alright, mate. Have you done it today?
Ah, fair enough. I'm engine.
I'm staging for us. League exactly for
Yeah.
Good food. Sam, how are you going? Sweet. Yeah, fine days. I'm here. I'll shoot up in here.
Did you walk up this bit?
Yeah, so you do the parts there, but to go to the other side. Yeah, if you need anything, give us a shout.
And then you look down.
No, it was good.
At least
It was pretty good. It was so much practice.
I've heard afterwards. That's it. was great. I know. I'm familiar with those. Yeah. That's like leaving. I've rode them back. I knew more an email manual. They've probably gone past. Also, just the phrase photograph
We can do a video of us.
Boss's last word yesterday is you guys Well, I mean, I suppose it's a small person. And a 1, 2, 3.
I got snapped on the phone. You do justice to Pokemon.
Hooray! What are you here for?
Call 42.
Oh, yeah.
Are you covering it? Is anyone doing it?
Huh?
Are you covering it?
Daddy is.
Busy day? Well, busy for the first hour, and then I got to sack it off until later on this afternoon.
I mean, I hope to God that people don't overreact and say, oh, we should put it completely, because that's just no problem. It's just nonsense. Sure, somewhere Sean knows he's crying. Yeah, she's nice. You get to know the security fairly well. One team's league team. No. Possibly time. No, that's what I thought.
lose it, I ain't getting it back. Exactly. My camera, please.
Bianca.
Mate, away, yeah?
Bianca.
I'll have enough.
See everyone here for you. Harry. Harry.
You'll walk closer to the wall. Yeah.
So I can file them now to let everyone know that he's here.
Supreme Court.
That's continuing.
It's like
Arrest that man. Oh wait, Jenny.
Just need to dangle a pole off this down the easy.
Yeah, just fucking overshot.
Well, he will be. Well, we hope he will be. You think he will be? I ate, well, I don't know the course necessarily, but I ate the fact that it makes such a big deal.
see you.
Yeah, and you. I'll tell Jess to message you.
Yeah, I mean,
I don't think so.
so I'll see what that's going to do. I imagine. I suppose so.
Yeah, people.
Hello, you alright?
I don't see you.
Ladies. Oh, sorry. See you later, mate. Got the shop?
Yeah, there's something that really close to it.
I assume you're up there.
Yeah, I was up there. I'm just gonna leave this for a second.
Yeah,
Look
sure.
a bit further out to get more signal.
Yeah, no, I'm still on live, so I'll be there for another 5 minutes or so.
No, it's fine. I'm happy to go up. I'm okay, like all the way down there. I'm happy to. I'm really not fussed about this stuff.
Yeah, just to play out mine. And then we'll work out the Denver. I don't know if it's going to stay all day long today. Lunch break. 10 a.m. Decent air.
Life goes on.
Well, he's not going to do anything else, so if you guys want to run down the creek or something,
Life
sit
goes
there for...
Yeah.
Phone. My phone. Oh, the seat, the chair.
Yeah, the chair. Yeah, the
This is out to south, so
Yeah, but I'm like, on my own. god, I didn't use it.
That is the perfect one.
Because then, see, it just like, yesterday.
Yeah, I saw you with the camera yesterday and that just like hanging from your back and I was like, how cool. I saw like there was a guy from
do we still
one like that as well. And I was like, you know, I kept on asking him like, where did you buy? Eventually he was like, okay, it was Kazan. I was like, oh, Kazan doesn't know this anymore about you.
Oh no, I'm just debating. It's my
Where did you buy it?
This? Or this?
Ah, celui-là.
Ah, vous savez pas, bon. Mais je l'ai pas acheté en fait, c'est la tu peux les prendre. Non, moi par contre, moi je n'utilise pas, donc si je me suis juste qu'ils m'ont dit, bah, prends une échelle, je sais pas. Enfin, c'est pas vraiment une échelle, c'est tout ça. Un coup, un tabouret, même pas. Je sais pas, mais j'appelle pas ça une échelle. Parce qu'en plus, quand tu filmes là.
C'est vrai, c'est échelle. Moi j'ai une échelle.
Ouais. Mais après, ça dépend d'où tu viens, quoi. Moi, du coup, vu que là, en fait, c'est mieux pour tourner la cam, quoi. Donc,
Mais en fait, là, ils étaient déjà tous alignés, ils étaient là, oh putain, c'est quoi?
bah oui.
Tu sais, je passe une fois, je passe deux fois, je me mec, il me regarde en mode, pas de chance. Et qu'après, ils me mettent devant un gars, puis c'est après, non, j'aime rien voir. J'étais pas sûre, tu vois, de où ça allait se mettre, parce que j'ai vu hier et tout. Et en ce moment, j'ai mis un sac, tu vois, tout seul. Et j'ai regardé, je me suis dit,
C'est moi qui me suis s'il vous plaît.
ouais, mais c'est vraiment ça que
Ah oui, parce que hier, du coup, c'est vrai qu'on a vu plus tôt. Et je pense qu'il y avait plein de monde qui était devant aussi. Parce qu'on savait pas trop. Du coup, là, tout le monde poussait du McDonald's. Et
là,
derrière, devant, quoi. Du coup, moi, j'étais là-bas, en vrai, un peu plus peut-être genre vers la gauche. Et elle me dit, ah, c'est là. Enfin, là. Non, j'étais devant. Mais de toute façon, il ne va pas sortir avant un peu.
Oui, c'est ça. Moi, tu peux les filles. Ouais, c'est ça que je sens. Ouais. Imagine, ils prennent mon sandwich.
Il est qui là, le sandwich? Non.
La petite famille, tu vois, non.
C'est drôle parce que du coup, hier, en fait, c'était tellement de temps à attendre. J'étais sûre qu'il n'allait pas venir. J'étais sûre que c'était énorme de ouf. En fait, comme tu pouvais le voir en live sur Sky News, moi j'avais le live sur mon tel et je regardais et je voyais un peu de temps en de la salle. Si en fait, c'était avoir c'était faire des lives. Donc là, par exemple, il y avait un rêve, mais tu n'as pas le droit de faire. Par contre, tu voyais grave, en fait, sa cravate avec ses costumes et tout, donc tu vas dire, oh, c'est lui, tu vois, et il est là, tu vois pas sa taille, mais en fait, tu leur vois là, tu vois, mais si tu venais de le filmer avant, tu vois, assis sur un tabouret,
Mais à la fin, là, quand tout le monde après, ils étaient tous en train de papoter, on ne voit pas partout, les nouveaux. C'est la première que je fais avec lui, je passe. Je parlais avec un mec.
et même si t'as pas le meilleur, tu
Ça
vois.
va. Là,
Et comme tu avant de...
tu fais quoi? Le fait que toi, tu mets du hier. Maintenant, c'est là.
Parce qu'en fait, il faut t'appuyer sur ma batterie. Je l'allume, tac, tu vois.
steps out and you see you just have to sort of be ready to move as soon as you notice that you're probably someone probably security guards. I'll take the life from the front door. Do you want to go down there and try and get him? So until 1 o'clock, you're free to go and play somewhere if you want to. Get something to eat, get warmed up. Stick where it is, but I'll grab the other afterwards.
I got everything here.
Okay.
Actually, I think that was not that good. At some point, I got like a little nervous about the battery. I was like, I push the battery like a battery, like just fuzzy, like you know, just kind of
$2. I think it's about 25%.
Yeah, still okay. Yeah, but yesterday was everything was out of battery. Like my say my friend, like the other one. I know you take it, you shouldn't be like
Yes.
sorry. Yeah, today's really like temperature dropped like all of a sudden.
Yeah, yesterday was cold in the shade, but the sun eventually came over and really got very hot. And today it's easily cold.
I don't know if it's gonna be sun. I'm glad today I'm wearing a long coat.
Yeah, it's good.
This is very
Yeah, it was also like this morning.
wasn't it really nice one like you leave it on the door every second. It's falling apart. It's getting like actually I'm very happy to put it in. It's freezing.
These ones are really good. Like I got a small one as well. Like the stuff. And like yeah, there's like feathers coming from everywhere. Like it's like I'm flying in and stuff. But at least like
Does that remember that? But 8 years ago?
16.
I'm 16. No, but like that's not 8 years ago. It's still departing from a real threat now. They do, because yesterday then I was like, oh,
Good morning.
Good morning. I hope you should have in hard copy, and I hope it's reached you electronically. I asked it to be sent direct to clerk. So
What's supposed to have reached me?
there's a document entitled Summary of Respondents' Core Open Submissions.
Yes, thank you. Yep. Lovely, thank you.
Do you have that electronically?
Yes.
I'm rather hoping that does what my Lord invited me to do yesterday, but it does it for each of the 4 heads that I'm going to address you under. And it gives you the basic propositions, which I will develop if I may orally, but at least it will save you taking down
Can
the
this
notes.
be provided openly to others?
Yes.
Good. Well, then it may be provided to the press.
Yeah.
Thank you.
My Lords, as you'll recall, we were yesterday on the interpretation of the 2017 RAVEC.
Just before I did ask
Yes.
Ms. Fatima if she could put her points
I think
in
she's done that
writing.
too.
Have you done that?
My lord, yes. I believe it was sent to you yesterday evening.
Unfortunately, it hasn't got to me yet, but I think by saying in open court that it hasn't got to me, it'll get to me very soon.
We can certainly try our best to resend again.
Thank you. If it could be resent, that would be helpful. Thank you. Sir James, sorry.
As I was saying, we were on interpretation of the 2017 terms of reference, and when we finished yesterday, I was about to make the submissions, the 5 submissions, and you see the basic 5 flagged in the summary document. Can I just invite you to cast an eye down them, and then I will develop each of them if I may. So far as the first is concerned, the terms of reference are internal guidance to assist in decision-making by RAVEC and setting out the key divisions of role between the various different bodies involved in a highly specialised context with experts, as it were, running the show. They are, as you know, internal. I think they were designed, as the evidence demonstrates, to be shared, although they, of course, have been shared by way of disclosure in this litigation. And indeed, that he hadn't seen them, the appellant hadn't seen them, was part of the now gone procedural fairness complaint that was rejected by the judge and isn't renewed here. But for this purpose, the point is that this is internal guidance to those involved in the decision-making, very much with that focus. It isn't public-facing guidance. I'm not making a great song and dance about publication or not publication. Of course, there are certain circumstances where the public don't see it, whether guidance can still be a policy of the requisite kind. But this one definitely wasn't public-facing guidance.
But this is guidance of a kind that ought to be followed if there's not a good reason for following it, you would say.
Well, my Lord, what we're on at the moment is the pure issue of interpretation. Does it set immutable rules? We'll come to good reason in due course and the standard and the rest of it, and whether there was good reason.
But you're making a lot about the type of guidance. That's
Yes.
why I'm asking the question.
I'm making a lot about the type of guidance as a part of the context in which you interpret this document.
Okay.
And it goes, as it were, to lightness of touch, if I can summarise it that way, rather than heavy-handed, rigid rules. One's drawing that comparison. That's the purpose of it. It wasn't, as it were, like immigration guidance or policy, which is designed to deal with a big run-through of cases where the fundamental importance of having that species of guidance, that type of guidance, is to ensure across a wide range of factually very disparate cases consistency of decision-making, and people can see and make judgments about how they act and react on the basis of what they see in that immigration guidance. Those features are absent here. It isn't therefore remotely akin, we submit, to statutory policy controlling those sorts of large flows, for example, through the immigration system and the immigration guidance and so on that you are all very well aware of. It's much more fluid than that. That's its context, that's its basic nature. And we submit that the judge was right to recognise that basic nature as part of this exercise of interpretation, still under this first main submission, as he did at paragraph 156 in the judgment. In a nutshell, the TOR, the terms of reference, are for the use of experts, and by experts I include all of those in the various bodies that are referred to, RMB, RAVEC, Met Police, anyone else who's involved in the decision making and so on. They are for the use of experts in making the various judgments that are called for by the context. That's the first main submission that you have in the summary. The second of them, I read that briefly just so that those who are listening can follow the argument. The second submission is that there is nothing to suggest that the terms of reference are designed to make provision that must be followed and cannot be departed from, or have exceptions created, or that a bespoke process that is judged better to serve the ends of the decision-making, applying the guiding principles in the TOR, cannot be done. There's nothing to suggest, to put it a slightly different way, that they were intended to operate rigidly, inflexibly, and without the ability to tailor decision-making and its processes to the facts of the case under consideration. And of course, as you're very well aware, policies more generally may often be framed in apparently unqualified terms, and all will recall some of them in the Good Law Project case, but will still need, in fact, to be designed, and are in fact designed and intended, in a particular context, to admit of exceptions and qualifications. Sometimes that is because it is necessary, in public law terms, to ensure that whatever policy or guidance you put out doesn't fetter your discretion. That would be extremely problematic if you were operating under a statutory regime, as you know. Here, we're not operating under that sort of regime, but it makes the position a fortiori. We're operating under royal prerogative, where there aren't, as it were, those statutory framework controls.
Well, can I just ask you this? We said at paragraph 59 of the Good Law Project case, we do not find there is a duty to comply with the 8 policies. You remember the 8 policies about WhatsApp messages and so on. Is there a duty here on RAVEC to comply with this terms of reference?
My Lord, the answer to that question is yes, as long as you understand what it means and what it's intended to mean. That's why I start with interpretation. We're not running a species of non-justiciability argument.
Yes.
If I may, still on intention in the second submission, that there are good reasons of principle, therefore, against it being designed in a hard-edged way rather than a fluid and flexible way. The principle is the one I've described: need to avoid fettering, need to leave it open, must apply a fortiori to royal prerogative because of the absence of a statutory framework, but also good reasons of practice, because to take any other approach would fall straight into 2 problems. One of them is the policy, not law distinction, and the second of them is to adopt what we respectfully submit with respect the judge was correct to characterise, see, for example, paragraph 178, as the appellant's, quote, mechanistic and overly literal approach to the 2017 TOR. Still on the same theme and the final point under this second submission, it is not surprising, we submit, that documents such as this, such as the 2017 TOR, do not specifically address all cases. They don't address unusual cases like this one. And that illustrates a broader point, which is that it simply isn't helpful to approach the language of what is in the TOR as if they were intended to do that. And it makes little specific sense to complain that the terms of reference don't provide for the sort of bespoke process adopted for the appellant. Almost by definition, a policy won't provide for a bespoke process outside its ordinary run of operation. But a policy should not, in principle, we submit, be interpreted as precluding the need to deal with those cases if they fall through the run of cases that go through the system, as this one does. And unsurprisingly, perhaps, no complaint is advanced by the appellant that RAVEC is continuing to consider his case. he hasn't fallen outside of this process at all. He's considering his case and continues to do so, notwithstanding that there is nothing in the terms of reference that directly or expressly allows for that. But that's just the flip side. That's a reflection of the obvious need for flexibility and pragmatism and a high-level framework document such as the TOR, providing the sort of guidance it does. So that's the second submission. The third submission is perhaps the most important. The most important feature of the context here as integral to correct interpretation. You have this summarised on page 1 of the short document I handed up. The most important feature of the context here as integral to correct interpretation is the nature of the exercise that those acting under the terms of reference are undertaking. And we submit, just to develop that a little bit, if I may, we submit that a reasonable person, and no one's quibbling with the idea that it's the reasonable person that we're dealing with, see Raisi and other very well-known cases, the reasonable person would clearly understand that the core objective of those functions, i.e. the functions of those with responsibility for making decisions under this process, is to make nuanced judgments about security protection, bringing all of their expertise and experience to bear, including, I would add, making decisions about unusual cases and what process should most appropriately be followed for the run of cases going through that system. The core objective that I've just described is not consistent, we submit, with the sort of mandatory, rigid, rules-based approach that is being suggested as the intended interpretation here. And at paragraph 158 in the judgment, the judge recognised that the subject matter at issue and the expertise and constitutional responsibilities of the relevant decision makers were relevant to the task of construing how this policy was meant to work, how it was intended to operate, and the nature and the scope of the things that it was intended to permit. He also found at paragraph 175 and 178 that the terms of reference fall to be read in a more nuanced way by reference to, as he put it, the significant knowledge and expertise in the highly specialist area with which we are concerned of our witnesses, including the unremarkable proposition at 175 that, as he put it, they can be taken to have a thorough understanding of the RAVEC terms of reference, a point which accords with the principles we looked at yesterday from Hopkins Holmes. As you will recall, I don't go back to that. So this context, including this objective, is, we submit, entirely unlike the sort of cases and the sort of policy that the courts were considering in other cases, including in particular the immigration context, which forms a large part of my learned friend's cases relied upon. The judge correctly noted at 159 of the judgment the absence of any statutory context. This is an aspect of the royal prerogative. There is no statutory framework. But it's not just that technical legal distinction, as it were. It is the very context that I've just described which distinguishes and renders inapplicable and unanalogous cases from those very different contexts. That's the third proposition.
You're going to tell us how they're inapplicable. In other words, which parts are inapplicable and which parts are applicable from immigration cases that have been cited on the other side.
My Lord, I am, and I'm going to come to that particularly when we come to consider good reason, what does it mean, how does it work, and all of that. But in terms of this exercise of interpretation...
No, I understand it's not here.
It's not here, but I will come back to it, I promise. The Munjaz line and all of that, I'll come to them, of course. Fourth proposition, in such a context, it isn't just, as it were, flexibility isn't just neutral. There are positive advantages in not having the terms of reference as rigid rules, but rather as guiding principles to be applied flexibly to the circumstances of particular cases. the prerequisites, to go back to the very basics, the prerequisites for considering inclusion within, as it were, those cases that RAVEC considers are set out in Mr. Hipgrave's first statement at paragraph 25, supplemental bundle, page 85, all of which is confidential, so I don't...
But the problem slightly with that submission is that actually over time the terms of reference and the evaluation criteria have become more prescriptive, not less.
Well, my Lord, they may have become in certain respects more detailed. My submission is that they haven't become more prescriptive, if by that you mean they've gone closer to being rigid rules than being flexible guidance.
They do seem to have much more content as time progresses. We saw in 2008 there's one side of a sheet of paper written in rather mercurial language, and now there's pages and pages of things.
My Lord, none of that I deny. My submission is that it doesn't affect the essential nature of them.
Okay.
It simply provides more detail, not an alteration of nature.
Right.
My submission under this fourth main point is that each case does fall to be considered and should fall to be considered, both procedurally and substantively, on its merits, in accordance with the particular circumstances of the case. And there's nothing to support a case that bound RAVEC through the terms of reference into either identical processes or still less identical outcomes in relation to particular fact patterns that might appear. There's no dispute on the evidence. I made the point clear yesterday. I confirm it. There's no dispute at all that, for example, RMB risk analysis is indeed the usual approach in the usual case, and that the role of RMB may be thoroughly important in the usual case. But there was nothing about the appellant's announcement in January of 2020 that he was to step back from his role in the royal family and live most of the time, at least, abroad, that was usual. It was, to use the Latin, I know we're not allowed to, but to use the Latin, it was inherently sui generis. In other words, it was a category of its own. It was a unique set of circumstances. That's the fourth proposition. The fifth proposition focuses on the particular language, which my learned friend's submissions already at least drifted a little way away from, but I do respectfully submit on the skeleton at least form the linchpin of the argument. In such a context, will, which is the word used in paragraph 20, as you'll recall, of the 2017 TOR, will, not maybe or can, does not even suggest that it was intended to create an obligation of some kind. You'll recall that in paragraph 20 of the 2017 TOR, the will word was all under the heading of key tasks. So it was simply describing a task or function, rather than being in the form of something that creates mandatory obligations. And the judge was right, we submit, at 162 of the judgment, to conclude that even at its highest, paragraph 20 could not be applied to all or any individuals who demanded protective security under the system, precisely because there were value-laden judgments as to who should be treated as falling within the RAVEC cohort, to what extent, if you do fall within, what is the most appropriate procedure, what is the most appropriate outcome in terms of protective security. So all the value judgments in question to be made as to whether a person fell within, and if so, what security should be provided, would in fact be informed by an RMB assessment. That's the question. Would it be informed by an RMB assessment in circumstances of the exceptionality of the appellant's case? And we submit it isn't appropriate to refer to RAVEC as it were exercising a jurisdiction in a strict sense. What it does is to simply make discretionary, value-laden judgments as to the appropriate and proportionate use of public funds to provide protective security to royals and VIPs where that's justified in the public interest. That's the essential nature. And so we submit that the judge was right to emphasise, as he did repeatedly, that the terms of reference require those value judgments to be made, both procedurally and substantively. And it might be thought, but all the more so, those points are all the more forceful, given the description, accurate as we submit it to be, of the essential nature of the RMB process. Can I just invite you to go back to the judge's judgment at 229, paragraph 229. Starts at page 158. And his description of it, accepting a submission that I've made, is at the top of page 159. It is an analytical tool. Accordingly, given Ravet concluded that a better tool was available in the form of the process described in the letter of the 28th of February, there was no procedural unfairness, and so on. But it is ultimately the RMB process, an analytical tool that informs, or may inform, those value judgments. And once that is evident, it's equally evident that whether the analytical tool is in fact useful and the most appropriate process to go down, and certainly in relation to any suggestion that it was intended as a matter of interpretation to be mandatory in all cases, becomes untenable. It's simply a tool in considering the issues as to whether someone should have protective security under RAVEC, and if so, in what form. And the question that has to be considered by the decision makers is whether or not that is the most appropriate way of doing things. Is that an analytical tool which they wish to reach for in the particular circumstances of the case? We note finally in relation to this fifth point that on the evidence it's perfectly clear that RAVEC did not in fact apply or operate the terms of reference as if they set a whole bunch of hard-edged rules, but did treat them as providing guidance to the sort of decision-making, the myriad different types of decision-making they'd have to make in relation to the cases which they had to consider. So that's what we say about interpretation. I turn then, if I may, to the second argument, and I'm going to take this in two parts. The first, the respondent's notice, and the second, the way in which the challenge is made on this appeal.
I mean, you, despite all that, which I understand, you accept, I think, that the proper interpretation of the terms of reference is that an RMB analysis will be done before a decision is taken. That's what it says.
In the usual run of cases, what we're arguing about on interpretation is whether that's an immutable rule that has to be followed in all cases, including this one.
Implied into it is in the usual run of cases.
Yeah. That's the sense of the interpretation. That's what divides the parties. My learned friend says, as a matter of interpretation, RAVEC has no option. It's bound by the wire on the cage. And we say it's more elastic than that and plainly intended to be so.
And do you say, as I think I put to Ms. Fatima, that your case was, well, this is not, this kind of exceptional case is not mentioned in the terms of reference?
Well, I do, and I made that point, I hope, clearly during the submissions. But it's a very important point for a variety of different reasons. From the perspective of interpretation, and the debate that I've just described between the parties, it's important for this very specific reason, which is that it illustrates that they're not intended to cover all fact patterns going through the process. If they were intended to provide, as it were, a complete and hard-edged code, we couldn't do anything.
Yep, okay.
That's the point for interpretive purposes. I'll come back to the significance of it at other stages of the argument, but thank you for the reminder. I hope I've made that point clear. My Lords, I said that I was going to take the second argument in two parts. As you'll recall, the appellant's second appeal argument, as I described it yesterday, is that when considering the legal standard to be applied to the good reason to depart test, the judge was wrong to show respect, says the appellant, to the primary decision maker, to recognise that there was no statutory context and to place weight on that and to draw on the analogy with the Thameside duty. But essentially it's a submission that says wrong to accord respect to the expertise and experience and democratic accountability and so on of the primary decision maker. That's the appellant's case, but there are logically at this stage two different points, and the first logically is the respondent's notice point, which is if you get to this stage and you're looking at the reasons to depart and the wrong, whether there's good reason to depart and so on.
I don't want to be difficult or take you out of your course, but I do want to unburden myself of a thought.
Yes.
I know the court shouldn't have thoughts, but I've had one.
Better to unburden sooner rather than later, perhaps.
Probably so that we don't. I want to know what your submission is and Ms. Fatima's submission. It seems to me at the moment that it might be the case that we are asking the wrong question, because what I would suggest is that if there is, let's assume, a liability for this policy or failing to follow this policy, and that's obviously subject to everything we've said and its true meaning and so on, the question is whether the authority has failed to follow the policy as interpreted by the court without good reason, and that it might be said that the question is not to be split up in the way that both sides seem to want to split it up into two questions: whether the authority has failed to follow the policy as interpreted by the court, and secondly, whether there was in fact a good reason, which is what leads you to make your respondent's notice point about the second question. But if you ask the question, which seems to me to be actually the question, has the authority failed to follow the policy without a good reason, then that answers both sides of it, and you don't get into irrationality or not, because that has all the nuance that you need, because you will give whatever deference is due on a sliding scale depending on the kind of decision maker, and you'll look at the failure within the context of the interpretation by the court. And I was struggling with this in putting to Miss Fatima yesterday that she was breaking this all down into too many boxes, and that public law is not about boxes. It's about seeing whether something has gone seriously wrong in the administration of government, and if it has, of course, there will be liability. But it's not about having some sort of flow chart of decision making where you ask question one, and if question one's yes, you go to question two, and question three, and question four, and you come out with an answer which may be totally illogical. And this business of breaking down good reason and failure to follow the policy into two separate watertight compartments, I balked at that, and I wondered what your submissions were about whether.
My Lord, I have, if I'm allowed to have sympathy with the intervention from the court, I have some sympathy with that, and of course you will appreciate.
I'm sure I need sympathy. So
yeah, no, but I have particular sympathy, if I'm still allowed to use that term, and
yes.
a particular sympathy with the idea that public law is not about boxes, and it asks sensible questions in context with a view to seeing whether something has gone seriously wrong. So I don't mind that. The difficulty perhaps is that one does sometimes have to judge what it is at the very base level a policy means, and that does relatively frequently arise as a matter of public law. That's why the line of authority based in Raisi is set as it is. So you have to start with what the policy is requiring you to do on its face. That is a logically prior question, so although there may be some capacity to merge that principle recognised in public law.
No, I think you're missing my point.
Well, then I'm sorry.
I'm not suggesting that Vaisi and what the policy is not a separate question.
Right.
What I'm suggesting is that when you come to compliance with the policy, the question is not just have you failed to comply with the policy, but have you failed to comply with it without a good reason.
Well, my lord, I think we both agree that that is the right question.
Yes, but it's only one question.
And I think we both agree that it's only one
Good.
question.
But then that's
But
absolutely
you
fine.
still have to answer. I'm afraid there is a but. I'm sorry to push back.
You don't say it's a rationality question, the failure to comply question.
I don't say that the failure to comply question is a rationality question. I say the judgment of whether or not there is good reason to depart if it means a particular thing.
And then you do break it down into two.
And I do say that as a matter of public law, when you are assessing good reason, there is a straightforward choice, which is not an unfamiliar choice to public law, particularly when you take into account human rights cases, which is a particular issue for the court to determine for itself, or is the relevant issue an issue which is for the primary constitutional decision maker to take, subject only to public law control through rationality? That is a very well recognised question that arises across the sphere. I mean, to take the Human Rights Act example, my lord will recall that at the heart of one of the issues, at least, in the Rwandan appeal, was that question as to whether or not the divisional court had got themselves in a bit of a muddle about what the nature of the approach was, and the muddling question was, had they decided, in effect, that they should be asking whether the Secretary of State was entitled to reach certain views which smacked of rationality, or was the correct approach, as my lord and the Supreme Court ultimately found, that because this was a human rights issue, it was well established that this was a matter for the court to determine, ultimately, as the decision maker. And I do submit that that type of issue does arise here and hasn't yet been determined. In other words, when you're assessing the good reason, may ultimately be a very, very fine dividing line, because we say that even if it's good reason for the court, there's still a question about how the court goes about doing that, and respect is integral to the how question. So there may be a very fine line between these two, but at least in principle there is a distinction between an approach that says good reason is a matter of rational judgment for the Secretary of State on the one hand, and good reason is a matter of objective decision making for the court, and we would add brackets, applying the correct approach to that question, which involves according proper respect if there is expertise in play. So that's why I've divided it in this way. My lord, can I mull on that as I make the submissions? I ought to give you the submissions anyway. So
yes, no, give me the submissions. I think a bit of mulling is due, because to accept that you ask the question in an incomplete question, which is have you failed to comply with the policy,
does risk muddling everything up.
Yes, because actually the whole thing is to do, the deference question is on a scale.
Yeah.
Depends on what
bit of it you're talking about.
Yes.
No, I see that.
And you can't really answer have you failed to comply, because you say at one end of the spectrum, well, they didn't really fail to comply, because the policy may have said you should have an RMB, but it didn't address this type of case. At the other end, they say this is a black line policy. Yeah. You have to, but you can't answer the question of who's right without considering
who's applying it and what deference
who's applying it and what deference you give, and who understands the policy and all the stuff. And so, in the end, if you put it into watertight boxes, you are prone, I think, in public law to get the wrong answer. Now, everybody, that's at the moment where I am, and I'm not sure it benefits either side. Actually, I think it's just a better way of looking at it. I think it's a better analytical approach. That's what I'm putting to you, and
my lord, yes.
If I'm wrong, of course I'll be correct.
No, my lord, you're not getting, as it were, total pushback. I just wanted to
take time to
see if there were facets that needed to be thought about.
Because I don't, this is an important case. We don't want to get it wrong.
No.
And we don't want to knee-jerk. It's, it's something where it does actually raise. The only point which is new, I mean, the rest of it is factual, perhaps, and normal public law, but this is a new point, I think, the question of the test to good reason. Only Lady Hale had something to say about that in the Court of Appeal, and she wasn't upheld in the Supreme Court.
Yeah. Well, yes. But listen, I
okay, on you go, I'll shut up.
Can I, for the moment, as it were, because that's how I've structured the submissions, as it were, with recognition that the issues may bleed, you may need a composite approach, it may at least help to have the way in which the arguments, if you did spit it out, worked before you, so you can see whether there is, and if so, to what extent that overlap.
I'm not going to do what some judges do, which is think their idea is the only idea in town. You carry on, make your submissions as you planned, and just have a think and give me your considered view at the end of it.
Thank you. Thank you. So on the respondent's notice point, if we're there, if this is the right way of looking at it, if it requires a separate analysis, we submit that this is a question, whether there's a good reason to depart, is a question for the rational judgment of the authority here exercising its prerogative power. The basic principles, before I come to the submissions that you have on page 2, which I will develop again in the way that I did with the first heading. We're now on page 2 at the top, good reason, rationality, standard. You've got the 6 submissions there. But just before getting there, clear the ground. The basic principles are well established. Policies are not law. Policies may have legal effects. See Good Law Project, My Lord's Judgment, paragraph 63, Authorities Bundle, page 996. Those legal effects may include the principle that an individual may have a public law right to have his case considered under whatever policy has been adopted, and that is Mandalia, you saw yesterday, para 31, Lumba, para 26, per Lord Dyson, Authorities Bundle 323. However, having regard to the wide array of contexts in which policies of various kinds are adopted, policies, guidance, what's in a name, it is not the case that every policy or provision within a policy will attract that right. That was the public law development, as it were, that recognition that flowed out of the Good Law Project case, paras 55 to 56, Authorities Bundle, page 994. But none of those basic principles directly, at least, answers the question as to the standard that will be applied in assessing whether the decision maker lawfully decided that it did have good reason to depart from the policy. And that's the point at which I jump into the 6 submissions in the summary document. And the first of them is that from first principle, whether or not an authority has a good reason is to be assessed by reference to rationality, because the choice to depart from a policy is the exercise of a discretion. And the public law principle is that exercises of discretion are, as to their substance, subject only to the high hurdle of rationality. And the entitlement, just to develop that a bit, the entitlement of a public authority to depart from a policy for good reason is both a reflection that a policy is not law, and not to be interpreted as if it is, and that it will generally be the case that a policy must not operate as a fetter in the exercise of the statutory power in question, which is the most common form of discretion that one has. So they positively cannot, as a matter of public law, shut the door, whatever the terms of the policy, to the possibility of an exception, and they therefore have to they will therefore have to decide and consider whether or not to make an exception. And that's a classic exercise of discretion. And it's a classic exercise of discretion in that public law sense, because the constitutional underpinning is the same. It is the executive and not the court which has the function of deciding whether it's appropriate to apply the policy or to do something different, to make an exception, to react to an unusual set of circumstances in a particular way. And it's the executive, not the court, which is accountable for that decision making. So that's the first submission. The second builds on it, which is that the decision whether or not to depart from a policy is a classic exercise of discretion, not materially dissimilar from the exercise of discretion involved in how to apply the terms of a policy. So application of the policy in a particular case is a matter of discretion, and the latter is well established to attract the rationality standard. We know that, for example, if you take up electronically or physically the authorities bundle and go to page 898, tab 22, I'm after Lord Reed in the Begum case. And 898 you see para 124 by the letter C. Can I just invite you to read that? Particularly that second half. On the other hand, the question of how the policy applies to the facts of a particular case is generally treated as a matter for the authority, subject to Wednesbury. That is most obviously the correct approach, whereas in the present case, the application of the policy expressly depends on the primary decision-maker's exercise of judgment. If she's satisfied that doing so would expose individuals to a real risk, is the example given. And can I invite you also, in that respect, to have a look at Lord Bingham in the Mullen case, at paragraph 12. That's in Authorities Bundle 1, tab 4, page 129. And you'll see in particular the fourth point that he makes in paragraph 12, which goes over the page to 130. This is about paying out under ex gratia compensation scheme, so royal prerogative again. But he says at second line on page 130, I consider that the Secretary of State must enjoy some latitude in the administration of the ex gratia scheme, so long as he acts fairly, rationally, consistently in a manner that does not defeat substantive legitimate expectations. His decision has not been shown to offend any of those rules. And we submit that that approach, those principles, apply all the more so where the nature of the judgment in question is not only a fine one, but necessarily involves the potential for predictive evaluation and national security in a context such as this. So that's the second submission. The third submission is that the judge was right at 159 to note that the point in question, should there be a departure, if that's the right way of looking at it, should there be a departure from the terms of reference in the context of the RMB, in other words, we don't need an RMB process prior to the decision in question, that question was very, very close to a complaint of a failure to make adequate investigation or inquiry on a Thameside basis. Indeed, that was part of the way in which the case was put below. Thameside, as you know, requires the Secretary of State or the authority, the public authority in certain circumstances, to conduct reasonable investigations to inform themselves prior to making a decision. And that's the nub of the allegation here in relation to the RMB. They didn't do the inquiry or didn't call for the inquiry that was there and was necessary. That is pure Thameside. And the significance of that for present purposes Of course, it is now in the context of the policy, but the essential nature is a Thameside nature. And as we know, a Thameside complaint does allow the decision maker the leeway that the rationality standard accords. And you have, in relation to Thameside, for that principle, that it's subject to and controlled only by rationality, you have the Court of Appeal, I think it was Lord Justice Singh and Lord Justice Coulson, I can't remember the third member, but the Court of Appeal in Balaji Gari, again a very well-known case, paragraph 70, don't invite you to turn it up, simply establishes that Thameside is a matter of rationality challenge only. Balaji Gari, paragraph 70, Authorities Bundle, tab 19, page 740. The fourth submission refers you to an authority that was handed down after the judgment by the Lady Chief Justice in a case called the Secretary of State for Justice and Snedden. And you have that, if you would, in Authorities Bundle 2, tab 29, page 1096. Again, it's a different context, of course. This was a case involving, as you see from the head note, it was a case involving the Parole Board and the Secretary of State and the intersection of their powers and responsibilities. And under the relevant statutory scheme, the Secretary of State in certain circumstances, and here the context was transfer to open conditions, the Secretary of State could ask the Parole Board for advice. There are obviously certain circumstances in which the Parole Board can give, as it were, directions to the Secretary of State, can produce judgments that the Secretary of State is bound by, in effect. This wasn't such a context. This was a context in which advice was sought from the Parole Board, and the question there was, what are the circumstances and what are the principles that govern the possibility that the Secretary of State will get advice from the Parole Board and not like it? In what circumstances could the Secretary of State depart? And there'd been a whole raft of first instance decisions building on the Bradley line of authority, in effect saying you need good reason or you need compelling reason for a departure from the Parole Board's advice. And in essence, what the Lady Chief and the President of the KBD and William Davis, Lord Justice William Davis, decided was that the position was governed purely by rationality. In other words, the Secretary of State could simply disagree with the Parole Board's advice, and whether or not that was unlawful was simply a question of rationality without any supervening imposed test or heightened test, as it were. And you get that, if I can just refer you to the paragraphs, you get that in particular from paragraph 33 on page 1109. Can I invite you to read 33 down to the end of 37? It's a little bit longer than the sideline passage, but page 1109, 33 to the end of 37, if you would. And then the disposition of the case, in effect, at 44 in particular. 45, perhaps, if I can just invite you to read those.
Sorry, just give me the paragraphs.
44 to 45, my lord, so sorry.
Thank you.
4 ones in a row, 1111.
Thank you very much.
I mean, 44 gives some support to the point I was making.
My lord, I had spotted that. It does, but you'll see why I take you to this authority. We submit that there is, of course, it's a different context, but we submit that there are some parallels, as it were. Translate that kind of reasoning into our situation. RAVEC will take account of its terms of reference and the role of the RMB and the way in which it's usually very useful and so on, of which it can be assumed to be very well aware, but it can identify and is entitled to identify reasons to depart from them in a particular case, which it may for itself consider to be both good reason and sufficient reason, but in reviewing the lawfulness of that decision, the court's role is to assess the rationality of the decision. Of course, that exercise will no doubt include consideration of whether or not RAVEC has taken account of the rationale for generally seeking RMB's advice and so on, as reflected in the TOR, but that doesn't involve the court substituting its own view as to the reasons and whether they were good or sufficient or not. It's a rationality test, in large part because of the fact that in that context, under that statutory scheme as here, the primary constitutional decision maker and the person who has to judge all of these things is the Secretary of State, or here RAVEC. And any other approach would therefore require the court to substitute its own judgment on the merits of that decision for the constitutionally accountable and institutionally competent decision maker.
I can't help thinking that all of this assumes that there is some binary decision as to compliance with the policy, so that it assumes that the interpretation of the policy is clear, and it is clear that there has been non-compliance, and then you move to the question of good reason. But actually all of the questions, namely the interpretation,
may feed back into a lack of clarity at that point.
And the good reason are interconnected.
Yes, my lord, I totally accept that.
And you cannot just say, I'm paying no deference to the decision maker in some circumstances, at any of those three stages, but how much will be on a sliding scale.
Yeah.
The whole thing's on a sliding scale.
Yeah,
that's what public law's about.
Yeah. Well, none of those basic propositions we have any disagreement with at all. And can I take it very, very quickly and give you the last 2 points super quickly so as not to try the court's patience any longer?
Very patient court.
I've noticed. My lord, the fifth proposition, as set out in the summary document, is probably doesn't require much development. And we thoroughly endorse the point that is made by my lord and the position here about the overlap between the various boxes that we're considering analytically. I mean, if one takes this issue, is it for the court to decide good reason, or is it a matter of rationality controlling the decision of the primary decision maker, versus it's for the court, but you have to accord lots of respect because that's entirely obvious for reasons I'll come to in a moment, and I've already flagged. That distinction becomes very, very fine, and it becomes particularly fine once one recognises that rationality itself exists on a spectrum. And so the intervention that rationality permits as a matter of public law is not itself fixed or immutable. It is reactive to context. So there are certain circumstances which are particularly anxious, where rationality itself as a principle will attract greater and more intense scrutiny. So that's the fifth proposition. The sixth proposition is that Munjaz does not provide binding authority rejecting rationality, I wanted to make 3 short points by way of development of that. You'll recall the bits my learned friend took you to them yesterday. I don't go back to them in the interest of time, particularly Lady Hale. But the submissions of these, the statements of principle in Munjaz and in Lady Hale's judgment in Munjaz particularly, are consistent, we submit, with either approach. In other words, either for the court or rationality. She is simply making the point that intensity of review varies depending on subject matter. And that's something which is a good point when applied to rationality. It's very familiar under rationality that intensity of review sits on a spectrum, as I've indicated. In that case, it's to be borne in mind, in other words, in Munjaz, the courts were dealing with a very different argument, and the argument was that there could be a decision to depart from the relevant policy for good reason or none at all. So you weren't really in a territory of review at all. It was more like a non-justiciability argument. So unsurprisingly, the court rejected that, but it is neutral as to the debate that we are having between rationality on the one hand and good reason giving leeway or respect on the other. It's also, for good measure, dealing with a very different context, a very anxious context involving the detention of mentally vulnerable persons, their patients, and its own particular statutory context. I do want to emphasise that, because this shouldn't be sidetracked into a question as to whether or not there was an obligation of some kind created by the statutory regime. There wasn't there, and no one's suggesting that there was. It doesn't turn on whether or not there's a statutory obligation of some kind. The relevance of the statutory context is that it may make clear, absent an obligation, just how important it is that there should be policy, there should be guidance issued under the statute which should guide decision-making across a run of very different cases that will have to be applied as consistently as possible for all sorts of obvious and good reasons, particularly when one's dealing with a subject as difficult and as anxious as the detention of those with mental difficulty or incapacity. So those are the 6 points we make about rationality versus for the court. In any event, and this is the second part of it, as it were, this is the ground of appeal, even if the judge rejected those submissions, as you'll recall in the judgment. He said, no, it's a matter for me to decide. But then the ground of appeal arises, even if the judge is right on the basic approach, and good reason is for the court, it is still, we submit, appropriate to accord respect to the decision maker in a context such as this, and what they thought was a good reason, in effect. And that's the subject of the submissions that I've sought to pull together at the bottom of page 2. You see the title, If Good Reason is for the Court Still Appropriate to Accord Respect to the Decision Maker in a Context Such as This. And I've given you the 4 submissions that we make there. I just wanted to develop them briefly, if I may. We've addressed this issue in our skeleton at 29 to 31. And we submit ultimately that the fineness of the distinction between this approach and rationality is recognised correctly by the judge, and it may be that this goes to my Lord the Master of the Rolls' points about breaking down the boxes, but as he concluded at 158 of the judgment, it doesn't matter which one is right, because you've still got the same outcome. It leads inexorably to the same outcome, whichever way you look at it. The particular point here, however, is that he was also right in 158 to recognise that the expertise and constitutional responsibilities of the relevant decision makers was relevant to whether there was a good reason, and in particular, he was right to hold that the judge must not substitute its own value judgment so as to violate the principle of separation of powers. Our context, I emphasise, has almost every feature that has been identified as leading the courts to respect and accord the widest respect to decision-making of the primary constitutional decision-maker in a context such as this. And just to give you 4 or 5 points to make that good, Ravek, as the delegate of the Secretary of State for the Home Department, is the democratically accountable decision maker. If the wrong decision is made, echoing that famous postscript from Lord Hoffman in the Raymond case, after the Twin Towers had been attacked, as you will recall, if the wrong decision is made, the fallout from that comes to the Secretary of State. She is the democratically accountable decision maker, and Ravek is operating for her. Ravek is able to draw on expertise and is itself expert and experienced in a thoroughly important way. So expertise is uniquely available to the executive in this context. Ravek's judgments are made in the context of and about security, including national security, as the judge rightly accepted at 157. It has to consider and weigh the impacts on the public interest of the consequences of, for example, an attack. And that isn't merely a predictive judgment, itself a ground for respect in its own right. You'll recall para 32, which I'm going to come to, of Lord Carlisle, emphasising that a predictive judgment was one of the bases on which you accord respect to judgments of the executive in this sort of context. But the subject matter is about as far from something that could attract empirical proof or a right or wrong answer as one could imagine. And the recognition of the executive's competence and accountability is underscored, whereas here the decision is made personally by the chairs of Ravek, with the intimate involvement of the chair of the RMB at the time, who are highly experienced and expert in these sorts of issues and what is and is not the most appropriate way of going about the decision making. And I emphasise that the decision in question is that of the independent chair of Ravek personally, not his officials, him personally. And he set out his experience very clearly in paragraph 3 of his first statement. I don't invite you to go back to it, it's in the supplemental bundle at page 35, paragraph 3 of Sir Richard's first statement. Extensive experience. Former chair of the Joint Intelligence Committee, permanent secretary of the Cabinet Office with responsibility for security, and by February 2020 been chair of Ravek for over a decade. This is a decision maker who knows how Ravek works, who knows how security decision-making within government works, who knows the merits and demerits of the RMB process, and what Ravek will need to do inside and out, back to front. It's hard to imagine a decision-maker more acutely familiar and better placed to form his own view as to what process will best enable Ravek to take the decisions he's envisaging will be required in future in the context of the unique and unusual circumstances of the appellant. And the judge evidently and correctly took the same view. See the first sentence of paragraph 175. And as you will recall from the 2017 terms of reference, paras 3 and 4, it is the chair who is responsible, and it is the chair who owns the risk, as it's put. In other words, it's the chair who is front-line responsible if Ravek gets it wrong. All of those themes, all of those features, all of those factors have been reiterated time and time again at the highest level in our courts, including especially, and the court probably won't need to go back to this because I'm sure you're all very, very familiar with it, the Supreme Court Lord Reed in Begum. Can I give you the paragraphs? I'm very happy to go back to them if you'd like to be reminded of them, but they are very familiar, I'm sure. The paragraphs that are key for present purposes, including the whole-scale adoption of what Lord Hoffman had to say about separation of powers, constitutional responsibilities, the reasons for respect, and all of that are paragraphs 55 to 62 in Begum. Paragraph 70, perhaps especially paragraph 70, and paragraph 109, and you find those in the authorities bundle, tab 22, page 878, then 882, then 894. And I emphasised that the predictive nature of the judgments involved was a feature in one of the reasons for according respect, alongside the deeper constitutional reasons for that. Can I just invite you to go back to Lord Carlisle just to remind you of the sentence, sorry, of the paragraph that I think at one point my learned friend might have been going to refer to, and then decided belatedly that it was either not necessary or that she didn't need to, but I think you probably ought to see it if you can face it. Lord Carlisle, it's paragraph 32. I think she took you to some earlier paragraphs, but 32 is really the pull together of the earlier analysis, including his pretty much whole-scale adoption of what Lord Hoffman had said in Raymond, but he brings it together in paragraph 32 on page 513 of the authorities bundle. And again, I'm not going to read it out because it's quite a long paragraph. Can I invite you to read the whole of that sideline passage? So you see all of the themes: democratic accountability, institutional competence, as it's put, all themes picked up by Lord Reid in the passages I took you to, predictive assessment, no right or wrong answer in the sphere of security. So para 32 is the key paragraph in Lord Carlisle, and he returns at least to the predictive theme in paragraph 46, if you flip forward to that on page 521, making the point, amongst other points, that, as he put it, the future as a foreign country, as LP Hartley almost said. And again, you see how he applies the themes from 32 in that paragraph, bringing back those basic constitutional ideas and playing them through into the facts of the case that he was considering, which is a case about whether or not an Iranian lady should be admitted to the United Kingdom for the purpose of discussing things with parliamentarians. I emphasise, because my learned friend referred to, and not quite sure what she was seeking to make of the Rwandan litigation, but she referred to it, but I emphasise that, as Lord Carlisle itself makes absolutely clear, because it was a case under the HRA about Article 10 rights, and I emphasise the point that respect is to be accorded for all of the reasons that are identified by Lord Sumption and by Lord Reid in Begum subsequently, even in an HRA case. And I put it that way because, as we discussed earlier, under the Human Rights Act, and as the Rwandan cases in the Court of Appeal and the Supreme Court and Begum itself make clear, in the HRA context, the question of violation is for the court to determine. But there is no dissonance or discordance between that and according respect, because this according of respect, which is now absolutely constant as a theme throughout all of the recent Supreme Court case law, including in the context of Article 14, for example, in the recent SC case and so on. But it simply goes to how the court goes about determining that question for itself. And so that makes the point that even if the court is the ultimate judger, the ultimate determiner, the ultimate decision maker of, for example, good reason or violation of the convention, it matters not. There is a question as to how it goes about doing that, and the answer is it goes about doing that by according proper respect to these sorts of judgments in this sort of context. It's also to be borne in mind that these points go, and they're pretty much flip sides of the same coin, they go to the breadth of the discretion that is accorded to a decision maker, but also to the degree to which the courts will scrutinise its exercise. And sometimes it's put in one way, sometimes it's put in another way. It doesn't terribly matter. But it is to be borne in mind that it applies to both of those things. And so the debates around rationality or how you take it into account and all of that don't depend upon how you describe it, whether you describe it as greater scrutiny or not. But we submit the judge made no error in according the degree of respect that he did to the issues in this case about what should be done in terms of process particularly, and in relation to the RMB, which is the main thrust of the attack, in relation to the unique set of circumstances that confronted Ravek here. And that takes me to the question, if good reason applies, what is the test? We submit that the answer to that question is a question, as ever, of context. Perhaps it goes back again to my Lord breaking down the boxes. We're not locked into some equation as a matter of general principle between, for example, what might be a good reason and what might be a compelling reason, however expressed, whether you use the Lord Hope language or you don't, whether those adverbs apply or they don't. It's necessary to appreciate that the description of the test is essentially a reflection of the respect due to the decision maker's judgments. In a context where high respect is to be accorded for all the reasons I've gone through as here, on all of the grounds I've indicated, the nature of what amounts to good reason is heavily influenced by their nuanced judgments to which respect has to be given. And what in truth my learned friend is doing by the constant repetition of the Lord Hope mantra is to narrow that without directly confronting its constitutional and principled underpinning. She seeks to narrow it by use of those language and that mantra without regard to the significance of their expertise in relation to this question. Of course, once one recognises that context is all and context will shape what the nature of the good reason that is required is, how intense the scrutiny is, however you want to put it, it becomes entirely unsurprising that there may be other contexts and other cases in which a more exacting standard is required, or in which a heavier good reason, if I can put it that way, may be required. It's just a question of context. So the citation of Munjaz in the present context as authority for the need, as it were, for compelling reasons, whatever the phraseology was, incorrectly, we submit, elevates a fact and context sensitive decision into a generally applicable principle, and that is simply incorrect. Indeed, in Munjaz itself, the House of Lords squarely and directly recognised that the standard required of the reasons in question would vary according to context. See for that recognition para 21 of Lord Bingham and paragraph 74 of Lord Hope, Authorities Bundle, pages 192 for Lord Bingham and 209 for Lord Hope. And similarly, therefore, when the policy is one that is issued under statute and has the statutory framework, which may go to emphasise how thoroughly important it is that all national health authorities operate in the same way to achieve consistency, or all immigration officers dealing with a run of cases going through, again, to achieve consistency, approach it in a particular way. They're simply features that go to the context. You can't build from the assertion that strong reasons are required in one context to anything like a general proposition. That is therefore those two bits of this second aspect. Would you just give me a moment? I just want to check something on the wording, a sensitivity question on the wording. Put it this way, because I'm very conscious this document may go to the press. In relation to this third question, this is good reason, application on the facts. Mm-hmm. Can you go to the summary document and go to paragraph 4? You see the final line says plans including. Mm-hmm. We're going, if we may, to delete the next 3 words. Right. And insert actual. You have the basic submissions there. This addresses the question, was there good reason to dispense with an RMB assessment? We've dealt with it in our skeleton 33 to 38. The judge carefully analysed both the contemporaneous evidence, which he'd gone through in enormous detail in the earlier part of his judgment, and the witness evidence. His analysis is principally on this issue at 166 to 173. And the upshot is that the good reason, as we submit it to be, is that the appellant's case and circumstances were sufficiently unique that the most appropriate way to take the protective security decisions in relation to him would be by using a bespoke process to consider the particular facts and circumstances applicable at the time. And we make the 4 submissions that I've set out in, or the 6 submissions that I've set out in the summary. The first of them is that it's critical to recognise the nature of the decision in question. Again, this is going to come as no surprise. As the Master of the Rolls noted, the decision was made in unique circumstances where the appellant had stepped back from royal duties and decided to spend most of his time abroad. The question was what to do about that in terms of protective security. This was not, I emphasise, treated as a case in which Ravek was no longer involved or didn't have jurisdiction in some way. It was considered with care. And the conclusion was, the February decision, which is what is being challenged, was that he would not continue to be treated on the same basis as before, so would not necessarily get all of the protective security that he had before, but that it was more appropriate not to make a once and for all decision, but to evaluate in the future, in the light of future situations, when he would be present in Great Britain, so as to assess the risks and so on then. And I emphasise also that nothing was excluded or shut down in relation to what might be useful or appropriate to do in the future, including, if considered useful or appropriate, which it might or might not be, to conduct some form of RMB assessment in the future. And it is the nature of the actual decision that frames the good reason analysis. In summary, good reason, question mark, for deciding that a bespoke process was appropriate. And the suggestion then has to be that an RMB exercise was necessary for that decision, So that's the first point, critical to understand the actual nature of the decision that's being justified, as it were. Secondly, the decision required consideration of a unique set of circumstances for which no provision had been made, even in the guidance provided in the terms of reference. That has, it is to be emphasised, not led RAVEC to throw up its hands in horror and say, we haven't got any guidance under the TOR, so we're not going to make a decision. Still less to decide that the appellant fell outside its remit, as it were, so it didn't have to make a decision. But it also emphasises that there is nothing in the idea that the terms of reference governed or bound the process in some way, including RMB, in this sort of case, because there was simply no provision for this sort of case in the terms of reference. So if, to the extent that my learned friend makes a submission that says, well, whether or not there's good reason depends on how hard you move from the policy guidance, we submit that you don't move very far from the policy guidance if the policy guidance doesn't cater for the unusual set of circumstances that you're dealing with. That's the second point. The third point is that the evidence was considered with the greatest care and in considerable detail by the judge, who was, we submit, entitled to reach the conclusions that he did. And we do submit that it should not be forgotten that this is an appeal. The question is, was he entitled to reach the conclusions of fact that he did? Not whether there's some sort of re-argument and that you should do it all again. Obviously, if the thing has gone badly wrong in principle...
unless you got the law wrong.
Unless you got the law wrong, exactly. Well, we're back into that. But otherwise, it's the strict test that you know about in terms of disagreeing with a judge on findings of fact. Particularly, it might be thought, in a case like this, where there are very prolonged arguments, there was an enormous quantity of documentation.
Well, I mean, I'm interested in your submissions, Miss. The argument on the other side had quite a large proportion of this part of the judgment was wrong on the facts. So you say, do you, that short of an argument that those were perverse or,
yes,
or simply wrong, could not be sustained, that was open to him unless he got the law wrong.
That's exactly what we say. Subject to the point we were discussing earlier, if you've gone badly wrong in principle, then the door gets open for
this is not a perverse appeal. This is not an appeal of the facts. This is an appeal
on the law.
On the law.
It is, my lord. That's a submission. But for good measure, can I do the fourth and the fifth submissions together, as it were, because then I want to develop them together, as it were. They are that the evidence indicated that the better and more appropriate course of action than calling for the RMB to produce some report was to consider the matter over time in the way that I've indicated, enabling consideration in the light of the actual facts and the actual plans and so on, and bringing to bear whatever expertise was necessary at that time. And not merely was that more appropriate, but that sort of bespoke consideration led and leads to no deficit for the appellant. And I wanted to develop those together, as it were. No deficit, we submit, from the nature of the bodies or their consideration of the issues, threat and vulnerability in particular. The makeup of the RMB is explained in Hipgrave 1, paragraph 56, supplemental bundle, page 92. The representation there, as I know my lords are aware, particularly from the question asked by my Lord Justice Bean, is very similar to that of RAVEC itself. There's a kind of overlap in terms of institutions. And of course, all of the expertise and so on is an institutional thing. It's not, maybe enhanced by the thoroughgoing experience and expertise of a particular individual, but it's basically an institutional point. And so it makes a lot of difference if they are directly, in effect, the same organisations in different guises. the RMB is not more expert than RAVEC. The latter, of course, that's RAVEC, has very senior security and policing specialists and can call for whatever other expertise it considers as appropriate in a particular case. The RMB is not more independent in some way than RAVEC. There is no basis whatever for the suggestion that RMB will be more rigorous. On the contrary, the basis for the bespoke approach was that it had positive advantages from a security and risk assessment point of view, because you'd be doing it on the basis of an actual set of facts. The RMB's role, as described in the evidence, is concerned with an overview, taking a principal's position generally in the round, and that may be a very helpful exercise, as the evidence makes clear, when someone is here all the time and has got an established role or activities. It's a great deal less so when they're here for a limited time and for unknown or various purposes. That is likely inherently to require a more flexible, more fact-specific approach. And that was at the heart of the judge's judgment at 170 to 174, and we submit he was entitled to make all of the factual findings that he did there. It is of some significance, we submit, that the chair of the RMB was himself intimately involved in the decision-making process and the run-up to the February decision by RAVEC. One can see that from the various exchanges in the email correspondence that the judge has assiduously set out in enormous detail, and one simply does the basic exercise of identifying from the paragraphs I'm about to give you in the judgment the extent to which there was communication about the thinking as it developed between and involving the chair of RAVEC and also the chair of the RMB. One sees it in particular from the judgment and its summary of the various exchanges and conversations and emails, paras 25 to 28, 30, 40, and then especially the ones that you looked at yesterday, 54 to 58, in which the judge sets out those emails, the paragraph 1 emails, if I can put it that way, at, I think it was 207 and 204 of the supplementary bundle. 54 to 58 of the judge's judgment sets those out verbatim, and he returns to that email exchange at 167 in the judgment. And my friend Ms. Fatima says rightly that an RMB analysis may be qualitatively different from a threat assessment. So it is. It undertakes a risk analysis which takes the threat assessment as its starting point and goes on to consider vulnerability, generating in the lingo likelihood, and impact, generating in the lingo risk. But that is precisely what RAVEC did. Mottram 2, Sir Richard Mottram's second statement, at paragraphs 24 and 32, supplemental bundle 151, expressly confirm that the key steps in the normal process were fulfilled. And I'm not going to go into the detail of all of that because it's confidential. So I may have to come back to that in the confidential session, but I give you those paragraphs, 24 and 32 of Mottram 2, and I give you also in that respect the current RAVEC chair's statement in the supplemental bundle at page 358. Suggest it may be better to put it at the end of the supplemental bundle. When you get there, can I invite you to go to, for this purpose, to 24 to 38 for the purpose of this point. And again, that's confidential, and so I don't want to go through that now. So the point we draw from all of this is that the basis for the decision-making and the bespoke approach being adopted was that it had positive advantages from a security assessment point of view, not the least of which was that it would be focused on actual facts in the future. And I note again, it wasn't shutting down anything in relation to the consideration of future facts, including, as I say, it may well not be, but a consideration of whether or not an RMB analysis might be useful. And the view of the chair at the time, Sir Richard, was precisely that the bespoke approach was positively better for informed, protective security decisions than an RMB analysis. And indeed, all of the witness evidence, all of it, is to the same effect. You recall, just give you some references, you recall the level of experience of Sir Richard, Mottram 1, paragraph 3, I gave you the reference already, supplemental bundle, page 35, chair of RAVEC for over 10 years, intimately familiar with the processes and nature of RMB assessments and their context, as well as their suitability for the appellant's newly changed circumstances. See also in that respect the views of the current chair, paragraph 22. See also Sir Richard's first statement at paragraph 77, supplemental bundle, page 57, mostly confidential, but ending with the words that the bespoke approach was, in his view, a flexible and tailored approach, better matched to the claimant's revised circumstances. He comes back to that in his second statement, paragraphs 35 to 37, supplemental bundle 154, especially paragraph 36, where he said the effect of that bespoke case-by-case consideration process would mean that an RMB would be unnecessary because alternative governance arrangements would be in place through RAVEC for considering individual requests on a case-by-case basis in context, and expressing the view at paragraph 37 that it made much more sense, as he put it, to do that for the confidential reasons that he gives in paragraph 37. And as he put it in 39 in that same statement, it was more appropriate and more useful to both RAVEC and the claimant to carry out the bespoke consideration of each request as and when it was required and in the particular context of the case. That's also the view, i.e. that that's the right way of doing this, of the current chair. See the witness statement of the current chair at paragraph 20, as he put it, and you ought to read the whole of that paragraph, but as he put it, a more effective and informed view could then be reached. It was the view of the senior Home Office official, see Hipgrave 2, paragraph 20, I just invite you to take that up, page 163 in the supplemental bundle. And some of it's confidential, as you will see, so I won't read it out. Can I invite you to cast an eye down paragraph 20? Setting out the detail as to why he concludes that it would enable a better and more informed process, as he puts it. All of that is accepted by the judge, and we respectfully submit he was entitled to do so. See, for example, and in particular paragraphs 170, 172 and 173. And I emphasise, and I do it on the basis that this was a point that the judge was well alive to, see paragraphs 85 to 92, reflecting Mr. Hipgrave's evidence. That's 85 to 92 in the judgment. All of those witnesses well understood at all times what the RMB process was, what role it played, what it did, and how it did it, including, I might add, the chair of the RMB with whom the matter was discussed in the immediate run-up to the February decision. So the court at this level, and indeed the court below, would have had to have disagreed with the unanimous view of all concerned, with all of their expertise and experience, that this process was the most appropriate in terms of the process to be followed, that it was not necessary to hold any form of RMB process for the purpose of this decision, and that there was no deficit in the process they proposed to follow from the perspective of the appellant. He was not being singled out, as it was put yesterday. On the contrary, the process adopted had positive advantages for him in the view, the unanimous view of all of those witnesses. I wanted to pick up finally on this aspect, the point about weight. My first submission, you won't be surprised to hear me say, is that this isn't really a suitable subject for an appellate point, because precisely it is about weight. That's a matter for the judge. There's nothing perverse about his approach. The judge, this is about the ex post facto, does it correspond to the contemporaneous documents, all of that. We submit that the judge was right, that the witness evidence was consistent with everything I've just described, and there was no reason not to accept that witness evidence in its totality, not least in the absence of any application to cross-examine those witnesses. See paragraph 177 of the judgment. And he directed himself, again correctly, by reference to Lord Burnett, Chief Justice's dicta in the 2022 Good Law Project case. See, for that purpose, for Lord Burnett's description of the principle, paragraph 86 of 2022 Good Law Project, Authorities Bundle 959, where he said the general rule is that the evidence of a witness is accepted, this is all in a judicial review, is accepted unless given the opportunity to rebut the allegation made against them, or there is undisputed objective evidence inconsistent with that of the witness that cannot sensibly be explained away so that the witness's testimony is manifestly wrong. A court hearing a judicial review will generally accept the evidence of the public authority, and it will not normally decide contested issues of fact. The judge directed himself by reference to that approach in principle at 161 of his judgment here. But the position as I've described it and the reasons for it are reflected not merely in the witness evidence, but also in the contemporaneous documents, including, in particular, the email correspondence between the chairs of RAVEC and RMB, respectively, that you saw yesterday and that the judge recited and came back to in the reason part of his judgment at paragraph 161. There is no element, we submit, of ex post facto reasoning. This is a wholly orthodox elucidation of the context and the basis for the decision as taken at the time. That's an ordinary function of witness evidence in judicial review, and we submit that it is entirely consistent with the contemporaneous documentation. So you are nowhere near falling foul of the sort of circumstance which Lord Burnett identified as being the limited basis on which you could raise this sort of issue. So there's no error of law in the judge's approach. and there is no basis whatever to conclude that his factual conclusions were perverse or that he should have given different weight to the witness evidence, which appears to be the way in which it is, in brackets, impermissibly, close brackets, put by my learned friend. Finally on this, the within the cohort debate that my learned friend sought to raise by reference to Mottram 1, paragraph 14, we respectfully submit that that is a non-point. It's a non-point because at no point did anyone suggest that the appellant fell outside Ravek's need to consider his case. They considered his case and they continue to consider his case. But as importantly, given that this is an appeal, the judge spent no time on that distinction. He did not find that the terms of reference didn't apply because the appellant fell outside them. Indeed, on the contrary, he assumed, correctly we submit, that they did apply, bracket, in his favour. Ground 2, to the extent that I can deal with that in open, if that's acceptable to move to that. We haven't, I'm afraid, given you call submissions in summary form in the document on ground 2, but the reasons for that I hope will be relatively obvious. The essence of this ground, I'll try and describe it as faithfully as I can in open so that people can understand what it's about. The essence of this ground is that Ravek was required to, in effect, admit the appellant permanently into the cohort of those entitled to protective security at public expense, because his position could not rationally be distinguished from that of certain other individuals for whom Ravek authorises that sort of protective security. The judge dealt with that supposed comparison, we submit, comprehensively and without error. See his judgment at paragraphs 181 to 191. But because this ground involves consideration not only of the appellant's protective security arrangements, which are themselves, for obvious reason, confidential, but also that of certain others, it isn't possible to deal to any great extent in open court with that, and that's why we're going to have the private session. At a general level, it can be said in open session that Ravek's approach is not to proceed by way of comparison in any event, and the judge correctly accepted that at paragraph 187, and that is for the obvious reason that it's highly unlikely that two cases will ever in truth be the same when judged against the broad guiding principles which apply. That's so not just because of the nature of the guiding principle and the absence of a hardline policy, but it's also because the concatenation of circumstances is likely to play differently in different cases other than perhaps the clearest ones. It's also perhaps because the guiding principles that do apply and require a judgment or an assessment or an evaluation. It doesn't involve an empirical analysis of some description with a right or wrong answer, quite the opposite, for all the reasons I've given. And those features, we submit, lead to the position described in the evidence. The decisions by Ravek are not made on a comparative basis or by seeking to analogize to others. See, for example, I don't invite you to turn it up now, but see, for example, Hipgrave 1, paragraph 31, supplemental bundle, page 86. Hipgrave 2, paragraphs 12 to 13, supplemental bundle 161. The current chair's statement at paragraph 9, and Sir Richard's second statement at paragraph 8, supplemental bundle 146. So the approach involves an individual assessment in all of the circumstances of that particular case. What Ravek considers are threat and impact factors are described in the guiding principles. No one, of course, I emphasise, is saying that comparisons may not, in principle, in some circumstances, be of interest, or, still less, that Ravek was not aware of them, or did not, in fact, consider them on occasion. nor is anyone saying that at a very high level, applying the guiding principles, they're designed to assess the protective security issues and so to distinguish inevitably between one case and the next. But it needs to be acknowledged squarely that it's extremely difficult and perhaps not very profitable to seek to compare cases other than through the broad guiding principles as applying across a range of similar cases. And I underscore the point that the helpful groupings by broad description, role-based, VIP, occasional, and so on, are simply that. They're not, and they're not to be taken as hardline categories or an invitation to compare, still less the creation of some form of legal game of compare and contrast. One only has to consider the very different individuals within the other VIP category to see that the only real link between that group is that they don't fit readily anywhere else. There is, in short, no departure from the previous position taken or inconsistency in the evidence, simply a working through of that approach, and that we submit is plainly a lawful and legitimate approach in principle, and it was the approach applied by the judge to this set of issues. So, in conclusion, then, we submit there is no proper basis for challenging the decision that bespoke assessment was appropriate. That was a position that RAVEC was entitled to take, a view that the chairman was entitled to reach. What mattered was the question of substance as to how they were going to deal with this unique set of circumstances. And to that issue, they brought to bear all of the expertise and experience that you're well aware of. So, my lords, those are my submissions in opening. I'll come back particularly to ground 2 in the private session, the closed session, but I may also want to pick up a couple of other bits related to ground 1, including, for example, ground 1D, but I'll come back to that if I may in private.
Have you got a revised timetable for from here on in? In other words, how long, Ms. Fatima, are you going to be in closed before you hand over to Sir James?
Well, my lord, I'm hesitant to estimate because I don't know the questioning I'm going to get, but based on my notes, I think I should be able to do it in 45 minutes.
45 minutes. And then, Sir James, you're going to take your hour.
Well, my lord, I might do. If she's shorter, I'll try and be shorter. We'll
Try and be shorter if you
possible.
can. Okay. So we can say, can we, then there's a reply, I think, in closed, a short reply in closed. So it should be an hour and a half, say, 2 hours max in closed, and it's now 12:15, let's say.
Yeah.
So we should be coming back at 3:15 into open, or 3:30, something like that.
Yes, and there may, I don't know what my friend's positions will be, but I suspect that I shall be very, very, very short in that revised opening session.
Yes, okay. So that's for the benefit of everybody who is now going to leave. We will rise for a very short moment in order to allow the court to reassemble with only those who are allowed to be here in closed. Thank you.
Did you say you would be an hour in closed? I just didn't hear.
No, I thought I'd try and get
This had a good right
just now I got a chance.
That's what I did. Yes.
If you're in the back, it's fine, so you can notice it earlier. Okay.
Prova audio, prova 1, 2, 3, prova audio, prova livello audio, prova radiomicrofono, prova. Prova, test audio, prova, test audio, prova 1, 2, 3, 4, 5, prova, test audio. Prova aula, prova audio, prova test audio, prova 1, 2, 3, 4, 5, 6, 7, 8, prova di amplificazione, distribuzione audio, prova radiomicrofono, prova 1, 2, 3, 4, prova 1, 2, 3, 4, 5, 6, prova audio, prova test, prova audio, prova audio test, Prova 1, 2, 3, 4, 5, prova test audio, prova 1, 2, 3, 4, 5, 6, test audio, prova audio 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, prova. Prova, test audio 1, 2, 3, 4, 5, 6, 7, 8. Prova test audio, prova 1, 2, 3, 4, 5, 6. Test audio, prova 1, 2, 3, 4, prova. Prova audio test 1, 2, 3, 4, 5, 6, 7, 8. Prova audio. Prova audio.
Our business, which is statements on tariffs, calling the Taoiseach.
Margaret agus Walmar ar dús gur gola míad bortha faoin méadtá tar éis tarlú go dtí seo ó thaobh an Gallagher de agus na taras go léir atá ar an bhód fí láthir agus mar tír sé bun agus bar cuasa Gallagher na tíre seo ná bheith ag $3 fud na tíre go hoscailte agus go fear leathan so níl éon áras ach go mbeidh drotheannachar ar na taras seo chósaíochtaíochta i gcuiteanna agus an éirdan mar aon le sin. For an open economy like Ireland, recent developments on trade have been especially concerning. Having enjoyed decades during which global trade has increased, new markets have opened and supply chains become ever more diverse and complex. And we are clearly now entering a different era. Ireland has supported, I'm sharing my time, I think, with Minister Pascal Dunham. Ireland has benefited and supported a world order in which trade has become more open and globalised. We now need to adjust to a different situation, one in which some are consciously stepping back from. The new policy approach in the United States is one in which the protection of national markets and the raising of protective barriers plays a central part. Ireland has and continues to advocate for an ambitious world trade agenda because we believe trade not only brings economic benefits, it helps lift people and countries out of poverty and it contributes to a more stable and predictable world. Indeed, the era of free trade over the last 30 or 40 years has led to the largest increase in living standards ever recorded in the world. Retreating behind defensive barriers may appear attractive on the face of it, but it is not a win-lose proposition. Ultimately, everyone loses, and the poorest lose most of all. And that's why the announcements on tariffs made by the US administration on the 2nd of April are so deeply concerning and regrettable. They have had an immediate and negative impact in global financial markets, and indeed there has been significant turmoil in the markets today. But the medium to long-term consequences for the world economy will be grave indeed if solutions are not found. A baseline tariff of 10% on all countries entered into force on the 5th of April, with further tariffs coming into effect today. And this will mean a blanket 20% tariff on all exports from the European Union, including Ireland, to the US from today. While major tariff announcements were trailed in advance and the government has been actively preparing, we did hope that this harmful and destructive step could have been avoided. These new tariffs are in addition to the decisions last month by the United States to impose tariffs on steel, aluminium and derivative products, as well as on the automotive sector. Together, the US tariffs on steel and aluminium, on cars and the blanket 20% tariff on goods from the European Union affect around €380 billion of trade between the United States and the European Union. There is no way to sugarcoat it. A 20% blanket tariff on most goods could potentially have a very significant negative impact on investment and on the wider Irish economy. It represents a huge challenge to Irish exporters to the United States, those who export to the United States across all sectors. We are already hearing from some who are seeing their orders from the United States slowing or even drying up entirely, putting valuable and skilled jobs at risk. And there may be more to come. We have yet to see the approach the United States will take on pharmaceuticals, semiconductors, and other sectors excluded so far from the so-called reciprocal tariffs. I hope the United States will reflect carefully before taking any further steps. Industries like pharmaceuticals involve deeply complex and interconnected supply chains, as we saw clearly during the pandemic. I have spoken to many leaders in the pharmaceutical sector and indeed in the medtech in recent days to discuss how best we can navigate these very serious challenges. I know how concerned they are. It is not a sector in which production can be turned on and off overnight. As we have seen in Ireland, the sector involves exceptional expertise, long-term research and innovation, very significant investment in high-tech plants that can produce to exceptionally high standards, a skilled and dedicated workforce, and most importantly, patients, people who cannot afford to see the price they pay soar or to have supply of vital medicines interrupted. I hope that, having reflected, the United States will step back from disrupting this most sensitive sector. I am sure that we can find a negotiated solution in which we can get a reasonable settlement. We see no justification for the imposition of tariffs on European Union exports. Tariffs are counterproductive, as I've said, and deeply disruptive. They drive inflation, hurting consumers on all sides. There will be no winners in this, least of all the United States taxpayers, who will bear the burden of higher costs. As stated starkly by the President of the European Commission, Ursula von der Leyen, the global economy will massively suffer. Uncertainty would spiral and trigger the rise of further protectionism. The consequences will be dire for millions of people around the globe, including the most vulnerable countries, now subject to some of the highest tariffs. I believe that the European Union response to date has been the correct one. As I agreed with President von der Leyen in our recent phone call, the European Union will proceed in a calm, strategic and measured fashion. We will be continuing to seek negotiated solutions. We are disappointed that we have reached this point, but it is always essential to continue dialogue and negotiation. There is always time to strike a fair deal. And this approach was endorsed by the European Union trade ministers at their meeting last Monday. There was a strong sense of unity and agreement that the European Union should take the necessary steps to safeguard its interests. All shared the view that this dispute requires dialogue and negotiation with the United States. At the same time, the European Union will have to respond in a proportionate manner, which protects our businesses and our citizens. Today, based on a proposal from the Commission, European Member States are considering a decision to proceed with counterbalancing measures in relation to the US tariffs on steel and aluminium. If agreed, they'll come into effect and they have been agreed on a staggered basis, first on the 15th of April and then on the 15th of May, and they will affect around 22 billion euros in trade between the European Union and the United States. The government has been in ongoing contact with the European Commission and has made Irish sensitivities clear. I discussed these issues directly with President von der Leyen, raising our concerns on the potential inclusion of bourbon and dairy on the proposed lists of EU countermeasures. I am pleased that the concerns of Ireland were taken fully into account. The European Union is continuing to reflect on and prepare countermeasures in relation to the tariffs announced by the US on the 2nd of April. However, as I said, and has been made clear by the Commission, the European Union is also prioritising negotiation and dialogue with the United States. Should negotiations fail, it will be important to consider further countermeasures by the European Union that protects our businesses and our citizens. Ongoing contact with the United States and the Trump administration is crucial if we are to convince the United States to come to the negotiating table. I raised our concerns about tariffs and the potential adverse effect and impact on the two-way and mutually beneficial economic relationship between Ireland and the United States when I met President Trump in the Oval Office last month. The Taoiseach had a useful phone call with US Secretary of Commerce Howard Lutnick on the 24th of March and is in Washington today to meet him in person. The European Union Trade Commissioner Maros Sefcovic is permanently engaged with his US counterparts. Last Concolo, I know that there are also serious concerns which I share about how the United States tariffs and EU countermeasures could impact Northern Ireland and the all-island economy. The new tariffs announced by the United States do not affect the United Kingdom in the same manner as they are subject to the baseline 10% tariff. This will have an impact on Northern Ireland, and the Government is conscious of this. We are working through these issues, and we will continue to be in close contact with the Northern Ireland Executive. There may be specific issues for the agri-food sector, not least due to the integrated supply chains north and south in this industry, and the customs rules of origin, which define the origin of a product for tariff purposes. We learned a lot about this during the Brexit period, so we understand that supply chains on this island are deeply connected, and that any change to current integrated arrangements would require huge investment. Minister Hayden and his team are looking at the potential impacts on the agricultural sector in more detail. The Windsor framework does offer some protections. Arrangements are in place that allow Northern Ireland traders to apply to United Kingdom authorities to be reimbursed in respect of EU import duty paid or deferred on goods brought into Northern Ireland and that do not enter the single market. But the impact of the new tariffs is wider than any one sector and will potentially impact all goods being exported, north and south, in different ways. We are very aware of this, and we will continue to highlight the particular situation of Northern Ireland and more broadly the all-island economy in all our discussions with interlocutors, including the United States and the European Commission. While the challenge we and our European partners now face is not to be underestimated, we are taking this on from a position of strength. Our economic performance in recent years has been robust. We have near full employment. We have seen real substantive jobs growth across all regions. And this economic success has been based on an openness to trade and investment with all countries, an approach we must continue to advocate for, including by calling for an ambitious European Union trade agenda. Ireland remains committed to the principles of free and open trade, which have underpinned our economic success. Free and open trade brings economic opportunities, creates well-paid jobs and fosters innovation. It builds economic resilience within a strong rules-based international trading system. And our membership of the European Union makes us part of a growing network of EU free trade agreements, supporting more opportunity for exports and investment, helping support jobs and growth at home, maintaining strict European Union standards on food safety, animal and plant health, and supporting better environmental and human rights standards around the world. And that is why we will be bringing forward legislation to ratify the Canadian-European Union trade deal. And I trust that on this occasion, the opposition will support that legislation because it's good for business, it's good for jobs, and good for small to medium-sized companies in Ireland. I've never understood the opposition to it, given that trade is the flesh and blood of our economy. And also, as members of the European Union, we want reforms. We want to double down on the single market, which should be a part of the European response, remove more barriers within the European single market, and develop a savings and investment union also through negotiation with fellow member states. Our trading relationships, in headline terms at least, in public finances that are our trading relationships have resulted in public finances that are in a position of relative health. We have also provided for significant reserve funds to ensure that we continue to invest in our country's future prosperity. We acknowledge that much of our budget surplus can be attributed to the strength of corporation tax revenues, a significant portion of which has to be considered a windfall in nature, and that's something that has to be carefully managed. In resisting the pressures to spend too much in recent years, we now have a strong fiscal position to start from. While we continue to work to address the risks we face and exert influence where we can, central in our response to tariffs must be a greater focus on increasing our competitiveness, controlling costs where we can, and on delivering critical infrastructure and investment, and in particular in driving the energy transformation in enabling offshore wind farms to be developed. The new programme for government, which outlines our commitment to delivering for all people in all regions across our shared island over the next forward in the coming months, an action plan on competitiveness and productivity, with a focus on issues such as the cost and regulatory burden on business, research, development and innovation, planning and regulation, and energy costs. And this will be an important plan setting out how we can continue our path of economic development, maintain our attractiveness for investment, and so forth. I've engaged with some of the most impacted companies at the highest level, helping inform our response. We are working closely with business and workers through the Labour Employment Economic Forum and the Government's Trade Forum, considering how best we can collectively respond to the challenges we face. And this means working constructively, as we have in other recent challenges, to minimise the impact on employers and workers and sectors affected, and to ensure our future economic prosperity. Our track record in protecting the economy and jobs, whether through Brexit, on COVID, or the war in Ukraine, is clear. The challenge we face now, however, is different. What is needed is a strategic and thought-through approach. We will be developing our analysis in coming weeks to better understand the impacts we face, including distinguishing between temporary and structural changes. We are facing into a period of high uncertainty, which could put considerable pressure on the public finances. We need to proceed carefully and manage the resources we have available. Already, though, we have in place a strong set of employment and business supports available to affected companies. Our state agencies are stepping up their engagement with industry. Supports are available, including grants for strategic assistance, market discovery and diversification, digitalisation and innovation. A global network, including Enterprise Ireland's 42 overseas offices, is already working with companies to find and develop new markets. And for workers, we have a short-time working scheme to help those placed temporarily on a shorter working week by their employer, and a new job seekers pay-related benefit to better protect the incomes of those who might lose their jobs. Most of all, though, we need to avoid being deflected from the core challenges which will sustain long-term prosperity, and that is investment in infrastructure, investment in our people through education, training and skills, investment in innovation and research, and a more focused approach to regulation and addressing costs in our economy. We will not be complacent in managing the challenges we face. The Government is committed to protecting our economy and jobs, to developing our enterprise base and to enhancing our attractiveness for investment, and in so doing ensuring our continued prosperity. And we do this as proud members of the European Union, an integral part of a market of 450 million people, one of the biggest markets in the world, and from where we are working with our EU partners, we can negotiate from a position of strength.
Minister Donnelly.
Thank you very much, Count Corla, and with your agreement and that of the House, I'd like to share my remaining time with Minister Chambers, and I am pleased to have the opportunity to address the Dáil today on the issue of where global trade now stands. It is now obvious that we are facing a trade development that is a major challenge for the global economy right now, and one that casts a very dark shadow over prospects for the economy. Tariffs, to put it simply, are taxes on consumption and investment, and they are bad for economic growth and bad for jobs. In terms of framing last week's announcement, it marks the intensification of a dynamic that has been underway for some time. That global economic activity is becoming increasingly fragmented along political lines. The government's view is that priority must be to de-escalate the current situation and to avoid increasing trade disputes. That said, this is not something the government or even the European Union can fully control. So it's important to take stock of where our economy is at in order to evaluate how well we might absorb this policy-induced shock. This now comes on top of a series of unprecedented shocks to the Irish and global economy. Our economy has proven resilient, and that resilience looks set to be tested again. But this resilience is clear and continued. It's evident in our labour market, where the employment rate has never been higher and the unemployment rate has never been lower. In addition, the inflationary shock has passed, and unlike previous episodes, we are now seeing some signs of the moderation of inflation. I know prices are still high, with the most recent inflation data at 1.8% in the month of March. Having said that, we're very conscious that the price level remains higher than before the pandemic and understand the effect this is having on businesses and on living standards. The strength of the Irish economy is also reflected in the public finances. Last week, Minister Chambers and I published the first Exchequer returns of this year. The data shows year-on-year growth in all main tax headings and an underlying Exchequer balance of nearly €1 billion. This has reflected the government's efforts at running budget surpluses where possible, so that we can respond when needed in more difficult times. While we face into the current challenges, therefore, from a position of strength, it goes almost without saying that we will not become complacent. We cannot. The world is now changing and changing rapidly. It's very likely that the fragmentation of trade along political lines will now interact with other structural challenges that are more long-term in nature. The ageing of populations, the high levels of public debt, and other changes that are underway now with regard to climate change and the rollout of artificial intelligence. So against this backdrop, it's essential that we continue to be careful with how we manage our budgetary policy to respond back to this time of change. With regard to the recent tariff announcements, we are now seeing changes that are historic in nature. Additional tariffs of 50% on Chinese imports to America have been announced, taking the total tariff to over 100%. To state the obvious, this now means that the tax on the import is now higher than the price of the imported Chinese good itself. Overnight, The President has also outlined his intention to introduce further tariffs. All of this will affect the global economy in direct and indirect ways. It will reduce trade between the US and other countries, limiting those countries' ability to increase living standards through mutually beneficial trade, and it will increase prices for people, particularly in the United States, lowering their real incomes. And finally, the reduction in purchasing power across different countries will inhibit their ability to trade with other countries, indirectly impacting trade elsewhere. So the risk is lower trade, lower living standards, and lower growth. And that's why, last count Corla, all these moves are so deeply regrettable. As the Taoiseach said a moment ago, they trigger lose-lose outcomes. So this is why the European Union and the Government of Ireland is very clear in its message. Through the EU, we stand ready to negotiate with the US administration with regard to tariffs, because we firmly believe that dialogue, that de-escalation is the best path forward. We all hope that this approach can bear fruit and that a more normal trading relationship between the EU and the US can still be restored. However, there's no guarantee of that. And notwithstanding the effect of such negotiations, it is likely that we will not return to the pre-existing rules of trade. International relations and trading patterns have been fundamentally changed, and European countries, including Ireland, must and will adopt. The recent Letta and Draghi reports very comprehensively outlined the work we can do here in Europe to strengthen our own economic foundations and improve our own growth. We must now do this work, at a time of great uncertainty. This represents opportunities for Europe, opportunities for Ireland, and I believe that these challenges can be overcome if we maintain the commitment to working together, to multilateralism, that has helped us achieve so much since we joined the European community 5 decades ago. The Irish economy, the European economy, has thrived on cooperation. Mutual respect, trade, and a rules-based economic order still remains here the path to improving living standards. I do believe that the world economy, and I strongly believe that the European economy, can absorb this shock, but only if we adopt, we adjust, and we can prevail with our fundamental values intact and our economies in a stronger position. With regard to the effects on the Irish economy, the government published recent estimates to allow us to better understand the potential impact of tariffs under a range of different scenarios. Depending on the scenario, as well as future countermeasures, modified domestic demand, in other words, measuring the economy, excluding the effects of larger companies, is the best measure of economic growth. And it would be between 1% to 2% below a non-tariff baseline of growth over the coming years. This would be accompanied by a lower than assumed employment growth, which would be around 2 to 3% compared to where we had hoped to be. In other words, employment levels could be around 55,000 to 85,000 jobs lower. This is an important piece of work. It gives our best guide as to where we could be with what we know now. Government must be able to understand the likely channels and the possible economic impact in order to respond as best we can, and this is an important piece, though not the only piece of analysis of this very demanding economic situation. So let me turn to what the government is and will do. We have been a very significant beneficiary of free and open trade and of foreign direct investment. With this in mind, the announcements, as I outlined, will affect our outlook. However, notwithstanding the current uncertainty in the trading environment, companies have very deep roots in Ireland. They have benefited from the very highly skilled workforce and the pro-enterprise environment we offer, still making us a highly competitive prospect for investment. However, we must do better. We must focus on how we can best protect ourselves against the current uncertainty, exploring how we could potentially diversify our trading relationship across the world. We must continue to support the largest employers in the state and small and medium-sized domestic enterprises up and down the country. We must focus on the factors that are within our control and within our influence. This means investing in human capital, investing in the infrastructure for the future, which I know Minister Chambers will refer to, and it also refers to the funds that we have in place to help us build up safety in our public finances and respond back to the challenges that we are now confronting. We are now in a deeply uncertain period for the international economy, and the implications for Ireland in the coming years are not yet fully clear. The policy decision announced last week marks the end of the many mutually beneficial decades of free trade enjoyed by the US and the EU. The global economy benefited enormously from this trade, with hundreds of millions of people in the least developed economies lifted out of absolute poverty owing to the opportunities created by more trade and deeper integration into the global economy. We are one country that has seen its living standards grow significantly from how we participated in this trading system. At an EU level, two-way trade now amounts to just over €4 billion per day, highlighting the importance of the EU-US economic relationship. We will continue to make the case for free trade and for the benefits it brings for all sides, a case that the Taoiseach, no doubt, is making today. The government is determined to protect our economy, to support and protect jobs and to keep our public finances safe. We will evaluate the steps that are necessary to do this, but we need to avoid doing anything that could create further difficulties for us down the line. In other words, the actions the government needs to take are ones that also need to be sustainable during this big period of change. This is why we'll continue to engage extensively with all who are affected, building on what has made our economy resilient to recent shocks, while investing to further boost our competitiveness for the next wave of international and domestic investment. Despite the storm clouds that are clearly gathering, I want to emphasise to the House that we are approaching the current challenge from a position of strength, and we will use this to our advantage in the weeks, months and years that await. We have weathered many storms now in recent years. We have done this by working with our partners in the European Union, by managing our public finances in a sensible way, by creating a pro-enterprise economy, and by keeping our economy and our society open to trade. In a very changing world, I'm convinced these elements will continue. Thank you.
I'm sure members won't mind if I welcome two schools from my own constituency of Carrick-Kilkenny, Windgap and Skiock. I've been reminded by Deputy Clear that they're here. And also from Deputy Collins to say Kappa Women's Cave Limerick are also here listening to the debates. So you're all very welcome. Deputy O'Donoghue, I beg your pardon. I'm sure you're all welcome and that you have a nice day. So, Minister Chambers.
Great to see the cooperation.
Local politics first.
And to welcome everyone from Limerick as well. And as has been mentioned by the Minister of Finance and the Taoiseach, the imposition of tariffs poses significant risk to our country, our society, workers, businesses and our economy as a whole. All deputies here in the House understand the genuine concern, anxiety and distress
all of this places on families and people across the communities that we represent. This will impact on growth, on jobs, and on broader inflation and cost pressures across the Irish, EU and global economy. Prior to and in the days since President Trump's announcement, much of the work of government in the period prior to it has been to try and mitigate and best protect the progress that we've made in recent years. We've been working closely with EU colleagues and have been trying to put plans in place to mitigate and safeguard the jobs, our economy and our society. As we saw with COVID, Brexit and other severe shocks that we've faced and overcome, we need to work to mitigate the risks and take the appropriate actions to best prepare the Irish economy for the medium to long term. But we approach this position, this challenge from a position of strength, and thanks to responsible and careful management of the economy and our public finances, we're in full employment with a highly skilled workforce and continued investment happening right across our economy. Only in the last week, we're seeing continued investment and job creation. Inflation has been moderated, much better than many of the other European economies at less than 2%, and we're still seeing strong economic growth and modified domestic demand projected to grow strongly this year and also reflected in the exchequer returns from Q1. We've recorded and continue to record a budgetary surplus and have invested more than €10 billion in our long-term investment funds, and these will be at over €16 billion by the end of the year. Europe equally approaches this challenge from a position of strength. We have a united bloc of over 450 million people representing a strong and prosperous single market which has built and improved prosperity and living standards over so many years. And there's already been extensive engagement and dialogue at EU level by the Taoiseach and also by the Taoiseach this week in the participation of the EU trade ministers. And we believe the best approach is a careful, considered and graduated response where we demonstrate Europe's strength but that we seek to develop a negotiated outcome. In Ireland and the EU, we value the opportunities, the prosperity and the economic growth that free trade creates. This is why we want to move this from a space of significant tit-for-tat and retaliatory measures to one where the EU, the US and indeed the broader global economy can have a deep, proper, meaningful engagement, and negotiation is key. Regardless of what may come in the coming weeks, we know that the rules of the game have changed, and indeed we know from the Department of Finance and others that the trends of deglobalisation have been embedding themselves across the world economy now for many years. So we must adopt an approach which will best prepare Ireland and our enterprise economic model for long-term changes. Enhancing our domestic and international competitiveness must be our priority to support indigenous and foreign direct investment and remain attractive for anyone who wants to invest from overseas. And a key component of this is investing in our national infrastructure. I received government approval to undertake a fast-tracked review of the National Development Plan last week, availing of the additional resources that are available to the state, including the funds from the European Court of Justice ruling, the share sales proceeds and the Infrastructure, Climate and Nature Fund, so we can develop more ambitious plans for national infrastructure for the future, which will enable that economic growth which is central. Priority will be given to housing, energy, water, transport and health digitalisation to drive competitiveness, economic growth, with a review to be completed by July of this year. Alongside this, a new infrastructure division is being established in my department with work to strengthen the expertise, overcome many of the delays and implement a short, focused programme of reform which is singularly focused on expediting the delivery of key infrastructure, which in many cases is taking too long. Europe is facing a competitiveness challenge which requires fresh ideas to encourage innovation, boost investment and lift productivity, as Minister Donoghue mentioned. We've got lots of recommendations from the Letta and Draghi reports which have been discussed now at length at a European level, and we need to see a move to actually embrace those reports and deepen the single market, deepen the integration that it can represent, trying to reduce red tape and balance regulation across the European system, so we support enterprise to try and develop and entrench a better capital markets union, which will be the key areas of focus for boosting Europe's global competitiveness. It's also important we examine state investment in a much more critical and strategic way, And that's why I'm also focused on responding back to, with the overall envelope of €105 billion being spent by the Irish state this year, that we demonstrate a continued focus on value when it comes to state investment. And that's why I'm also reviewing the public financial procedures, so we strengthen the value for money considerations on all current and capital expenditure. In the coming period, both myself and Minister Donoghue will be publishing a medium-term fiscal plan, and that will set out what's possible for the long term in line with the work of the Department of Finance, who are updating the various projections that we have, and that will set out how we can strengthen public services in line with the demographics, the wider pressures that we have, and indeed the programme for government priorities. This will set out our approach, which will prioritise protecting jobs, protecting the progress for our country has made in recent years, and supporting enterprise to drive forward further economic growth in this period ahead. But we enter this from a position of strength, with strong public finances, strong partners in Europe, and a commitment to strengthen our economic model, so we can address not just the imposition of tariffs, but the future challenges that we know we will face in the years to come. Thank you.
Deputy MacDonald.
As has been said, nobody wins in a trade war, but we know who loses the most. It's workers and families who carry the can in the form of increased prices, threats to jobs and livelihoods, and hits to their incomes. Trade wars aren't good for the prosperity of ordinary people, that's the reality, but this is the prospect that we now face. It is unprecedented to use blanket tariffs to force broader trade and foreign policy objectives. US blanket tariffs are an unjustified act of economic aggression, and they are going to damage the US and the global economy. Ireland's economy and the prosperity of our people are uniquely exposed to US tariffs, and this has been brought home by President Trump's comments over the last 24 hours, threatening again additional tariffs on the pharmaceutical sector. The sector received an initial reprieve, but the landing zone on pharma tariffs is still not known. In recent days, I and members of the Sinn Féin team, North and South, have engaged constructively with representatives from key sectors in the Irish economy, representatives of Ireland's pharma sector, and with the American Chamber here in Ireland. Pharmaceuticals provide massive employment in Ireland and form a significant portion of our exports to the United States. So the exposure and the risk is real and must strongly inform how the Irish government proceeds in talks with the European Union and the United States. It's clear to me that we need a tailored strategy for this sector to reduce the impact should President Trump push ahead with his threat. And whatever the reflexive instinct might be, counter tariffs are not in Ireland's interests. The SRI has been clear that Trump tariffs are damaging and that automatic counter tariffs from the EU would make things worse for Ireland. EU counter tariffs would have the potential to cost Ireland more in terms of a hit to our public finances, job losses and higher prices for Irish consumers. So any response must be carefully considered, calibrated, and take Ireland's economic interests in their totality into account. The response from the European Union must be planned, strategic, and aimed at getting the United States to withdraw from this disastrous approach. A tit-for-tat battle is a race to the bottom, and that's a race that nobody can win. So what we need are cool and calm heads and maturity. We know that negotiations, dialogue and the working of relationships will be absolutely key to resolving this crisis and to moving forward. The Irish Government must ensure that the EU does not take any action that could further damage our economy, our jobs and the livelihoods of working people in this country. The priority must be to defend Irish national interests. That means safeguarding jobs, helping Irish business to grow in global markets and ensuring that the all-Ireland economy continues to grow at pace. We need a plan for Ireland, for all of it, to de-risk our economy and mitigate the impact of these tariffs. And this means having supports in place at both state and EU level. It means contingency planning and ensuring that our strategies are tailored to the specific challenges that Ireland will now face. And of course, the government needs to do much better at what is within their control: supporting domestic business, investing in infrastructure, sorting out housing, sorting out childcare provision. Getting these things right has never ever been more important. And I'm conscious that in the past, government have used crises as alibis not to tackle these issues, not to invest in these matters. This cannot be repeated. Successive governments have not put the basics in place to attract FDI without complex tax incentives. They have failed to invest in the areas key to building Ireland's long-term competitiveness and attractiveness. We've been saying this for years, and that we have allowed our competitiveness to slip. And businesses, big and small, have been telling us about the issues that affect them. So the scenario we now face shows that this must change. By making ambitious, smart investment in these areas, we stand to reap a double benefit at a time of great volatility. We can raise people's living standards and we can build the competitive advantage of Ireland being a great place in which to invest, to do business, to secure a job, a great place to live in and to build a life. Protecting, growing and advancing the success of the all-Ireland economy is crucial to building Ireland's competitive advantage and our prosperity, and this has to be a high-level priority for both administrations on the island, north and south. It's a serious issue that we now have two different tariff rates on this small island of ours, and potentially two very different responses to those rates and the dynamic that is now unfolding around us. So we need to ensure across the island that businesses are supported, primarily with information initially. A government trade forum could play a useful role in that. We also have Intertrade Ireland, which operates between both administrations, north and south, to ensure that in the first instance, our business sectors, which will be concerned about developments, have all the information necessary, and then whatever other supports might be needed in the time ahead. So I'm asking those in government here to work hand in glove and in lockstep with their counterparts in the executive. The first step in this regard would be to convene the North-South Ministerial Council without delay, and I'm asking that this be done. I'm also asking that government hold an all-party meeting as soon as possible, and that practice be a consistent feature of how we collectively manage this situation. If we are to work together on dealing with the crisis that tariff imposition could have on the Irish economy, we need an effective, transparent, collaborative approach, sharing with all parties in the Dáil all of the information and the strategies being considered. It's clear what must happen and what must be the priorities for the government in the time ahead. The government must champion Irish interests in Europe and ensure that any response doesn't risk greater damage, job losses, price hikes for Ireland. We must ensure that the EU pursues a pragmatic policy of de-escalation without compromising on important laws and regulations designed to protect the all-Ireland economy, the environment, human health and important sectors such as agriculture. There has to be a real emphasis to ensure that the EU does not make retaliatory tariff decisions that make a target for the US of key Irish enterprise sectors. And there must be a real drive now to build our competitive advantage, to invest with intent in those areas that increase our attractiveness for investment, protect Ireland from external shocks and strengthen both our economy and our society. The chief responsibility of government is to stand up for Ireland's interests, to protect Irish jobs, Irish industry and the prosperity of our people. And government cannot take its eye off the ball on that score. There is far too much at stake. But if we focus on those areas that we can control, if we show ambition and vision in defending the prosperity of workers and the growth of business, then that is how we stand the best chance of weathering this storm, of building a future in which Ireland's economy and the well-being of our people can in fact be enhanced.
Deputy Doherty.
And Trump's tariffs are an unjustified act of aggression, and we know that they will damage the US and indeed the global economy, and a full trade war has the risk of unleashing a global recession, and that's the scale of the threat that we possibly could face. So the stakes are high, and now more than ever is a time for cool heads. Irish interests and the interests of ordinary workers and families need to be at the front and centre of every decision. It needs to be the prism which we make all of these decisions through. We can't get away from the fact that tariffs are taxes. They're either paid by the companies or by consumers, and we know that what Trump is selling the American people is a fantasy when he says otherwise. And Irish people are genuinely concerned in relation to what all of this means for them, what all of the tariff talks, the retaliatory measures from China, the countermeasures from America, and then the countermeasures again from China. And will this be the playbook that we see in relation to the United States and the European Union and Ireland? How will it affect their lives? To many people in this country, they're already being ground down by the relentless cost of living crisis, and they simply cannot absorb higher prices from tariffs. The people that haven't felt the benefit of the so-called good times know all too well that they are likely to be the first to be hit in bad times, and people are worried about their jobs, particularly in relation to particular sectors and those within the FDI sector. And we have to focus on what we can control. We have to use our influence externally, but we also need to look at what is within our hands. What can we decide on? And tariffs can't be used as an excuse to drop election promises. We need to strengthen our workforce by providing affordable childcare. We need to give people security by building the homes workers can afford. And we need to invest in apprenticeships, education and research. And we need a health system that people can access when they need it. Because there's an overlap between what people need and what our economy needs. And that is an ambitious investment strategy in public services and infrastructure. That has to include public transport, it has to include energy, it has to include water and roads, and urgently addressing the backlog in planning. There's not, I'm sure, a member in this House who hasn't been told by small businesses and large business, whether they're some of the largest in the country or the smallest, that the issues that are pressing down on them are the issues of housing, infrastructure, energy, costs, insurance. All of these things are within the grip of the Irish government, and we need to now send out a strong signal to people in industry that we are going to take our economic competitiveness into our own hands, that we are going to lead, and with no more lost time is going to be an issue and no more delays, that we're going to finally get to grip with the crisis that are facing this country. We also need to make sure that Irish interests are heard at the EU level, because we can't outsource this to Europe. We must have a strong Irish position on what works for Ireland. Trump is also openly talking about prying open markets and breaking down barriers. He wants unfettered access to every market. The US main trade grievance with the EU is the trade deficit, and Trump blames the deficit in goods predominantly on non-tariff barriers. What that really means is our standards and our laws, health, environmental and agricultural standards. And we shouldn't make any mistake about it, agriculture is very much in the crosshair of the American administration, and these cannot be dictated to us by any country, even one as powerful as the US. We must protect Irish farmers, we must protect Irish agriculture. So talking big on tariffs while making concession on laws and standards would be a mistake, and it would undermine our sovereignty and indeed our credibility. So I want to repeat a number of asks that we have today. We need a sectors assessment done immediately, and I asked that of the Minister for Finance last week, and those assessments need to be shared, because it is through those assessments we would look at how and if we need to have targeted supports to support enterprise jobs and employees. The All-Ireland economy needs to be prioritised. The North-South Ministerial Council will have an important role to play, and that needs to be convened, as Deputy MacDonald said, without delay. And there has to be also an issue of a word of warning. Europe, we know, are setting to look at a number of countermeasures. They will join Canada and China in relation to that as of now. But they are looking at a second set of countermeasures. And if you are looking at implementing tariffs as a set of countermeasures to what Trump has done, then the scale and the breadth of that will mean that you will push up prices on Irish consumers. in the middle of a cost of living crisis. The scale and the breadth of that will mean that you will impact on Irish jobs and Irish public finances. And that's not just what we're saying in Sinn Féin. The ESRI and the Department of Finance's analysis is that that is actually the case. So we need to be very, very cautious that we don't do what Trump has done, which is a reckless agenda that is going to impact on terms of US consumers, and that we don't fall into step in relation to the same thing. Because those countermeasures would be a tax on Irish consumers, and it would be Irish people and European citizens who would pay the price for that. We also know that using some of the tools in terms of the anti-coercion measures, which are being trumpeted by other countries, would have a deep impact in relation to Ireland's jobs and enterprise here. So it is time to take cool heads, not follow Trump down the road of economic self-sabotage, which would eventually be ordinary workers and families that pay that price.
Tá plan igen a bhuachtarán Americánach Donald Trump gan gan cíl gan plan agus le himplaí anna don seirach sanadar ire de muinte America ach de pobl haar timple an down freshen. The imposition of tariffs by President Trump are illogical, arbitrary, in many respects without any basis in reality in terms of talking about retaliatory measures without an evidential basis. But most importantly, or most fundamentally, will have serious negative consequences for citizens in America, but across the world as well. And it will be, unfortunately, as so often is the case, it will be the ordinary workers who will first see the implications if inflation rises up. Those who are on the margins are likely to be most affected when they look at their trolley of goods in the supermarket, and it is workers who will face the consequences if we see layoffs or a slowdown in investments. It is undoubtedly a very worrying time. I think it is important to have cool heads but a clear eye. We certainly should not panic, but nor can we underestimate the threats that are faced. We must take them quite seriously. There are many workers up and down the country. In my own constituency in Cork, where there's a very significant amount of pharmaceuticals and life sciences and different sorts of manufacturing connected to the US economy or to US businesses, right up and down the country. There will be significant concern as to people's futures, people's jobs, and how all these high-level discussions and how countries are exchanging tariffs and the tit for tat that goes on, what is that going to mean for them and their families? What I think people will want to hear is what the Irish government are going to do. What can we control here? And in my view and in my evaluation, Ireland has been left uniquely vulnerable due to the policies of successive governments that has relied excessively on tax incentives, failed to invest in our infrastructure and failed to diversify, and has left us uniquely vulnerable. And I think that that is a problem. What needs to happen at this point, and I've been saying this since February, there are 4 primary areas that need to be addressed. The first of which is using our voice at a European level, ensuring that the interests of Irish workers, Irish business and the Irish economy, that we use our voice to the greatest extent possible. I raised the issue in early March in relation to the dairy industry and the Irish distilled drinks industry. I welcome that it appears that they are not included at this point in time, but obviously pressure must continue because it's clear that the agri-food industry is very much in the crosshairs of the American administration. I note that some of the language, and it has varied a bit over recent weeks, that some of the language from government representatives has talked about the need to step back and the need to evaluate the situation. It's not, I don't believe that that was the government's first instinct. I think the first instinct was to ensure that we are, to whatever came from Europe, that we had to be centrally a part of any response without offering necessarily a critical voice. If the government is taking on board what we and others, including industry voices, have said, that is welcome, but I would be concerned that any actions in terms of a knee-jerk rush to retaliatory tariffs will have clear implications for Irish workers and for Irish citizens in terms of costs. We can't very well argue that what Trump is doing, and it is profoundly damaging to the American economy, and then to do the same thing to our own economy and the implications for workers and businesses. So there should be no knee-jerk reaction. Any actions that the EU has to take has to have a clear plan, a clear objective, and is clear-sighted in terms of what it intends to achieve. The second primary thing is in terms of diversification. We have become far too reliant on a small number of markets. We have failed to build up our own domestic economy, and that is a point that Sinn Féin has been making for many, many years. The third issue is the issue in terms of supports, and I echo the call made by Deputy Doherty in relation to a sector analysis. We also know what companies are exporting to the United States. It is possible to evaluate who is doing the exporting, make sure that we are meeting their needs and that we're reacting to that. And the fourth issue is in relation to infrastructure. I've been meeting, along with my colleagues from representatives of key organisations in pharmaceuticals and right across. The issue in terms of infrastructure, like I listened to the Minister and the Taoiseach talking about careful management of our economy, and I'm even aside from the whole issue of bike sheds and event centres and everything that goes from that, the amount that we spend on things like HAP because we failed to invest in social housing, the amount, and we talk about this huge success of pharmaceuticals in Cork. The next huge industry for Cork could be floating offshore wind. We don't have the electrical grid to support that. So the reality is these issues in relation to infrastructure have been around for years and they fail to be. And we hear the talk time and again, we're going to invest in infrastructure. It hasn't happened. It has left us vulnerable.
Garmagad. Since President Trump began his second term of office, the world, as we know it, has become a more volatile place. Now, his early statements about turning Gaza into the Riviera of the Middle East through a policy of ethnic cleansing shows just what an absurd thought processes are going on or that we're dealing with. The combative statements dominate American foreign policy, and that's now finding its way into economic policy. It's well known that Trump's imposition of arbitrary tariffs on the host of products manufactured in countries across the globe will bring pain to American economy and higher prices for American citizens. The EU is a massive trading bloc responsible for 2/3 of FDI into America. These ill-considered tariffs by President Trump will mean that America will potentially have to increase its debt ceilings, with all of the associated implications for American GDP. The only outcome will be the suffering of Trump's own citizens. So much for making America great again. Great for who, you might wonder. So too would be the outcome of this state if the EU rushes headlong into the pursuance of counter-tariffs. The escalation of prices of normal goods in an environment where people can ill afford the most recent price hikes is hugely damaging to Irish households. That is why we in Sinn Féin across the island have been calling for a measured approach from government aimed at de-escalating the situation. I urge the government to approach these choppy economic waters calmly and in the best interests of all of the citizens of Ireland. The possibility of differentiation in tariffs on the island further compounds the threat to our national economy. Clarity is required regarding the implications of the tariffs in the north under the terms of the Windsor Framework. There can be no economic hard border on the island of Ireland. Of course, if we governed our own affairs, we wouldn't be facing this discrepancy. We would be facing this hurdle in full strength of our national economy and not with one hand tied behind our backs. But to mitigate, I urge the maximum level of engagement between the Irish Government and the Executive, and I do welcome the engagements that have taken place so far. As was said, the North-South Ministerial Council should be convened immediately. Our island economy is inextricably linked in agriculture and tourism and across the supply chains, and food safety and food security is becoming increasingly important as well. During the Brexit negotiations, we with our allies in the EU and the US ensured that there was no hard border on the island of Ireland. The same diligence must be applied in this scenario in order to protect the prosperity of everyone on the island. In the face of a potential slowdown in our economy, I urge you to speak with your ministerial counterparts to ramp up public expenditure to address the deficits in infrastructure. There must be a sense of urgency and purpose if we are to have any chance of remaining competitive for the foreign direct investment and ensuring the growth of our Indigenous businesses. That's in housing, in water, in energy security, in transport links, in research and development, investment in upskilling, in lifelong learning, and in using the National Development Fund for what it was intended to be used for. We can never ask the most vulnerable of our citizens to endure the brunt of economic hardships again. The government did this following the bank bailout. This should never ever be done again. Do not make the ordinary Irish workers and the disadvantaged, the sick and the elderly, Trump's victims. Now is the time for the government to protect the interests of those living in Ireland, and also for the young people that we want to encourage to come home. We have to have housing for them. We have to have infrastructure for them. We need them here and we owe them. In the immediate term, that means ensuring that the EU is available to sit at the table with the US administration. There is long and mutual beneficial trade relationships between Ireland and America. From the ashes of Trump's tariffs, there must be an open door for these to be maintained and cultivated once more. This can be achieved by increasing, at this time, our diplomatic efforts across the United States. The value of the relationship we have built over decades is critical, and we in Sinn Féin will continue our engagement with US politicians, with civic society and with our own diaspora. We do not know what the next move of this unpredictable American administration will be, and we can draw some hope from the fact that some of the Republican Party are deeply troubled by the direction that their president is taking. What we can control is our responses. The government must ensure that the EU remains calm in the face of disruption and provocation. We must also use our own voice. We must protect the jobs, the businesses and our public finances, and we must above all protect the workers and families from the reckless and short-sighted economic policies that we have been presented
Deputy
with.
Smith.
Last Count Corla. I must say I was actually taken with, and I'm sharing time with my colleague Deputy Marie Sherlock, I was actually taken with the comments of the Finance Minister Paschal Donoghue in terms of his contribution earlier. I suppose, Minister Donoghue, who's been now Minister across the finance briefs for many years, through a number of crises, I think his general approach to things is one of, I suppose, calm. He's not one for hyperbole. So for him to talk about the global economic activity breaking increasingly fragmented along political lines, talking about storm clouds, talk about how this tariff-related issues will interact with other structural challenges such as ageing populations and AI and climate change and high public debt, calling it unprecedented. I hope that the Minister will, after saying those words, be more open to instruments that could help protect the Irish economy and Irish workers, seeing as he has set out what we all know, just how serious this issue is. But the truth is, at this point, we don't know how much damage these tariffs will do to the Irish economy. We do know that a 20% flat tariff will apply to all EU exports. We also know that tariffs on pharmaceuticals are likely coming, probably in the near future. There's a real risk here, maybe not in the immediate term, given the nature of the pharma industry, but certainly in the medium term. We've seen with the Trump administration's response to China's tariff, to China's own response to tariffs, that they are willing to essentially go nuclear. And I think what we're seeing now between the US and China is so concerning that there's further pressure on the EU to respond correctly in a serious manner, but in one that minimises the damage to our own domestic economies. Not an easy challenge, I'm certainly saying that. That is why we have to be as proactive as we can in our approach. There must be a comprehensive assessment across the economy of which sectors are affected and which jobs and potential job growth sectors will be affected. That will allow us to ensure supports where needed can be targeted, and that we can ensure we're developing the right instruments to deliver those supports. I suppose we can say with some certainty that the agri-food and dairy industries could be especially hard hit, with many small businesses coming under extreme pressure, with small exporters that make specialised parts in this industry being exceptionally hard hit. During Brexit, our European allies did stand firm with us in protecting both our economy and indeed peace on our island. We must now stand firm with those allies and work together to combat these tariffs. The EU does have significant power and agency, but that must be used wisely. This is a time to be strategic, whilst also being firm in how we negotiate. We cannot allow for a precedent to be set here where the Trump administration gets to bully its so-called allies and gets everything it wants. To that end, it is vital that across the House we see what the proposals from the EU will be before they come into being. This is not a situation where the United States holds all the cards, and while there will need to be negotiations, we come to these negotiations in a position to exert significant amount of leverage on the US economy, and we must be prepared to do so. The EU also has an anti-coercion instrument that can be deployed on tech companies if needs be. While we do not want it to get to that point, no option should be taken off the table. That is, of course, if the Trump administration are actually interested in coming to the table in the first place. At home, we need to learn from the past and be much more agile in how we respond to economic shocks. There are a number of measures that we in the Labour Party are calling for, informed as they are by our experiences through Brexit and the COVID pandemic, though acknowledging that neither of those two shocks are the same as what is happening now. As I've already mentioned, we want to see a comprehensive assessment on the impact tariffs are going to have on Irish companies and Irish jobs. Only then can we plan properly for how we can support our people, our workers and our businesses. We also want to see a short-term wage subsidy scheme. We'd like to see a marketing fund for those sectors, such as agri-food and dairy, to open new markets, and a credit guarantee scheme to support businesses. The concept of a short-term wage subsidy scheme, like the German Kurzarbeit model, that keeps people close to their employers in periods of uncertainty or turbulence, is something we in Labour have been calling for a number of years. Indeed, we're not alone in calling for such a scheme, with the Irish Congress of Trade Unions calling for such a scheme during Brexit for the agri-food sector, with IBEC also calling for a similar scheme. Such a scheme could support companies impacted by the tariffs to hold on to some of their skilled workers as they adapt to changed trading rules and help develop new markets. This could be a vital move to hold on to our economic competitiveness for when this storm passes. It would protect employees from redundancy with state subsidies and shorter working hours when companies encounter difficulties. Importantly, like the German Kurzarbeit scheme, it will guarantee that each worker has access to training or upskilling plan to both improve productivity and prepare workers for potential new opportunities. The scheme itself can be funded through the Social Insurance Fund and National Training Fund. Both of those funds are in substantial surplus, with the Social Insurance Fund running a surplus in 2024 of 2.7 billion, with an accumulated balance of over 10 billion this year, and the National Training Fund having a surplus of about €1 billion. Such schemes are not without precedent in Ireland. During the pandemic, we had the temporary unemployment wage subsidy scheme, and the Minister should be looking at any emergency measures in the Public Interest Bill to address the impact on tariffs. Again, emphasising that we're not calling for these exact same schemes. What we're calling for will be much more targeted and much more sophisticated. But what those schemes show us is that the state can act to protect jobs, and what we're calling for is that the state should act to protect jobs. While the details need to be established, we do know the big sectors that are going to be most affected, like agri-food, perhaps the pharma medical device sector. And of course, there will also be unexpected areas hit. Again, we need to ensure that we are agile. Other big sectors that are also now facing massive impacts, such as the Irish whisky sector. Many distilleries will be funded through long-term loans built against their stock, and they will need to provide targeted supports like more low-interest long-term financing and a marketing fund. The goal of state action now has to be focused on allowing companies to adapt to changed trading realities and retain as much as possible their skilled and experienced workforce. International trade has long been a powerful driver of economic prosperity. As a small, open economy, Ireland has benefited greatly from the free exchange of goods and services across our borders. Our trade relationships with the European Union, to the United States and beyond, have helped fuel our growth and bolstered the standard of living for millions of people in this country, although acknowledging that we are not without our problems, and we still have a number of structural crises that we need to resolve with the prosperity that has been created. Yet trade is not simply about economics, and again, this is what I found interesting about what the Minister for Finance said earlier. Trade is a tool for diplomacy and cooperation, and until recently in the Western world have looked at the mutual dependencies that trade has created. It's helped foster peace and stability. But just because the United States has decided to abandon diplomacy and cooperation, it does not mean that the rest of us have to. As an EU member state, Ireland is committed to multilateralism, to a rules-based trade and a rules-based order, and that will nor should not change. Our participation in the single market has not only boosted our economic fortunes, but has also anchored us to our allies who share our values of democracy, fairness and peace. Whether it is in Canada, Latin America or Asia, there are markets out there that we have not fully harnessed due to our hitherto very close relationship with the United States. But we must look at exploring these markets. We also need to acknowledge that the attacks on democracy that we've seen around the world are concerning. The fact that only 25% of global citizens are living under liberal free democracies compared to 50% in 2004 is a worrying trend. The rise of autocracy and authoritarianism that seems to have swept the globe needs to be a wake-up call for all of us to take a stand against the United States' attempts to weaken other democracies. What we can't understand, any of us or any economist of good, bad or indifferent or excellent standing, is why use tariffs? They've never worked. Nobody wins. It is a lose-lose situation. There has to be a motivation then within the US administration that they are being used in a weaponized capacity to hurt the countries to which they're being applied, which is more or less every country in the world, with the likes of Russia and North Korea being spared at this time. While this House has seen significant divides in the last number of months, indeed a lot surrounding the issue of democracy, now is the time to come together. We can work together with our allies in Europe to put pressure on America and on Britain to change course. We've done it before and we can do it again. But to those who are listening and are fearful for their future, this storm needs to be weathered, specifically to young people who have seen 3 global financial emergencies in their short lives and are growing up in an era of economic migration and emigration. This is a storm we need to weather. We need to show our young people that we in Ireland and Irish leaders are doing everything they can to protect their jobs and provide opportunities here so they don't have to leave our shores. That is the challenge of this government and indeed all of this House.
Thank you, Deputy. Deputy Sheriff.
That's Corla. This is a trade war that obviously none of us want, but which we have to respond to here in this country. So I think we need to be clear on a few things, and we have to say clearly to government, I don't believe anybody in this House is calling for an economy-wide wage subsidy scheme, as I've heard the Taoiseach and some others suggest over the last number of days. To do so would be disproportionate and unnecessary. So we shouldn't waste our time in a bogus debate about job supports or no job supports. What we clearly need is targeted wage subsidy supports for those worst affected sectors. And the reality, as we all know, is that there are a number of firms out there who are almost solely focused on exporting, particularly to the US, and they need our help now. They're in alcohol, they're in dairy, they're in car components, medical devices, and they're facing now the double whammy of the weak dollar and tariffs, and the impact has been immediate. It's obviously very different for the pharmaceutical sector, and we worry about them too. But the impact will be over the medium to long term for them, and of course we've yet to hear of the tariffs to be announced for that sector. But for the sectors that are suffering now, the reality is that some of those are high margin, others are lower margin, some have a high price elasticity of demand, others are much more immune to price changes. So no one size fits all, but we have to learn the lessons from the past. And in particular, we have to ensure that we allow firms the room to hold on to their staff while they while they try and divert to other markets. And when we look in this country, we have a short-term work scheme that is simply not fit for purpose. It is unconscionable that we would be asking workers to sign on the dole for the days they're not working, facing an absolute cliff edge in terms of their wages, when we have the firepower of the state to ensure that those wages are supported for a short period of time. We're not talking about anything long-term here, but for a short period of time to ensure that those workers who are around the country right now are worrying about how they're going to pay their mortgage, their car loan or the school tour for their child, that they can be supported in the weeks and months to come, while those other marketing supports and all the other supports from the state are put in place to help those firms redirect their trade to other countries. Back in 2009 and 2010, I was a young trade union official who had to go into workplaces to look at the finances of companies, unionised workplaces, that were facing very difficult situations. And the memories are seared into my brain of the devastation on workers' faces when I had to talk to them about the dramatic drop in revenue, the possible pay cuts, or indeed redundancies that were on the table. And the damage of those job cuts, those wage cuts on people's lives, on their skills, that damage was in this country for many, many years. It lasted for well over a decade. And when we compared that awful time in Ireland, when we went through a recession, where our deficit was through the roof, our country is almost unrecognisable now. And we have to use the resources of the state to ensure that those workers, particularly those in low and middle income jobs, are supported in the short to medium term, so that so that their wages don't fall over a cliff edge, and while their employers are trying to find other markets, that they are supported. The reality is that we don't know whether these tariffs are going to be short or long term. We don't know what Trump's true intentions are, but what we do know is that the impact to workers and their living conditions can actually be smoothed over by the state through temporary supports in the here and now, if the government chooses. And I would finally just ask that we move away from this all or nothing kind of diatribe that we've heard from certain members of government in recent days about an economy-wide wage subsidy scheme. Nobody's asking for that. We're asking for targeted supports for the sectors worst affected.
Minister O'Connor.
Thank you, Last Ceann Comhairle. And Minister, the tariffs announced by the US administration have caused concern and anxiety about the impact on Irish businesses and job creation across the country. The uncertainty surrounding sectors such as pharmaceuticals is adding to this. While I know the government has been preparing for this, it's regrettable that the US administration made the announcements. Nobody wins from tariffs, but it is important that the government continues to analyse these measures and their impact on our trade along with the EU Commission. The EU will have to respond in a proportionate manner that protects our businesses and citizens, and it is always essential to continue dialogue and negotiations. The tariffs represent a huge challenge to Irish exporters to the US across all sectors. And Minister, I'll talk about my own local area, Carlow, Kilkenny. I'm mindful of local farmers, distilleries and pharmaceutical companies who have contributed so much to our local economy and who are anxiously waiting to see the full impact of these charges. Future growth of the economy, and as I said in my own area, Carlow, Kilkenny, and the future job creation could also be under threat, and this is a huge concern of mine. And, we need to have continued development, around our counties and towns, and this is so vital. It is important that we protect jobs and livelihoods as best we can. And I welcome the Taoiseach and the Taoiseach and the government's continued engagement with the European Commission in order to ensure that Irish sensitivities are made clear. Tariffs are deeply disruptive. They drive inflation and hurt on consumers, and Ireland must remain committed to the principles of free and open trade so we can retain high-quality jobs and protect consumers from sharp increases in the price of critical goods. Free and open trade brings opportunities, creates well-paid jobs and fosters innovation. I commend the calm response of the government, and I hope that there is still time to reach agreement with the US administration. However, if this is not the case, I welcome the efforts of government alongside the EU Commission to ensure that the impact of these tariffs on our economy and future growth is as small as possible. Thank you so much.
Thank you, Minister. Deputy Crowe.
Thank you, Last Ceann Comhairle. Minister, I'm glad to have an opportunity to speak on this, and I think sometimes less can be more in these scenarios, because I think instead of having all sorts of suggestions coming from opposition benches and backbenches as to what course of action government should take, I think this is a very delicate scenario, evolving by the minute, unfortunately, and I think it's really important that we place full trust in Taoiseach, Taoiseach, Cabinet and negotiators who will attend meetings in Europe and also talk across the Atlantic with our counterparts in the United States. I think the imposition of tariffs is very retrograde. I think it's very backward. The last time we'd have seen this, I think, would have been sometime back in the 1930s, and the world has embraced free trade ever since, and how the world has taken off. We don't live in a perfect world. We spend every waking and living moment here in the stall chamber speaking about the problems our country has and how we'd like to fix them. But certainly free trade has benefited this country hugely in terms of job creation, prosperity. It has lifted all boats in this country and indeed across the European Union bloc. I place full trust over the coming weeks in Taoiseach, Taoiseach and Cabinet in terms of how they approach this. But I do think the approach needs to be one in step fully with our colleagues across Europe and that it's focused on jobs, livelihoods. I think this government is only in place a few weeks, but I think the previous government, of which I was proud to be here in this side of the House for those 5 years, showed that they had huge ability and agility throughout the COVID pandemic to quickly react to scenarios to ensure that things were stabilised, that jobs were kept safe, that if people lost a job, there would be the safety nets of social protection there. And I think that's something that the European bloc can pride ourselves on collectively. The European member states largely are made up of Western liberal democracies. We have good social protection systems. We can lean on each other. We can lean on the European Central Bank. But Donald Trump will soon enough have to rethink his tariffs. And I think Ireland needs to very much move as a European bloc on this. And every voice that we can use here in unison to support the position of government and the European Union is what should be done. And I would be disappointed if there's any voices in this chamber, in the course of this debate here today, that might say something very left field that will be picked up very quickly by media beyond our shores. Thank you.
Deputy McGrath.
Thanks very much, Laskin Corla, and I also welcome this debate and welcome the opportunity to speak. The stakes are very high, as has been mentioned earlier. We now have some more clarity in relation to President Trump's announcements, and he is clearly upending decades of international trade norms and relationships in a matter of weeks, and that's extremely serious. For Ireland, it presents a real threat. We are a small, open trading economy with a very strong foreign direct investment sector. So we know the consequences can be very grave, and we now see the back and forth between China and the US, and unfortunately it is becoming a runaway train in terms of increasing tariffs. I fully support the Irish government and the EU position on this. It is important that we give space. It is important that we take a cool, level-headed approach, and we give dialogue a very real opportunity to succeed here, and we do our best to negotiate our way through this particularly difficult situation. And that isn't in any way a sign of weakness. That is the right thing to do. That is the smart thing to do. But we also need to send a clear message that if discussion and negotiation does not work, then we will respond as an EU bloc. And I think that has already been made clear in terms of the response to the earlier tariffs on steel and aluminium. The EU is now responding, and I think that is the right thing to do. We know tariffs are counterproductive. They only result in dampening economic growth, economic expectations. They result in increasing consumer prices, inflation, result in unemployment, and have significant potential to cause a major international and worldwide recession. And obviously that's something we all want to try and do our level best to prevent. For my own constituency in Cork South Central, we have a very strong foreign direct investment sector, and I know these tariffs will affect all engineering, construction, agriculture and so on, but it is particularly damaging in the area of pharma, biopharma, medical devices, life sciences as a whole. And in my own constituency, there are a lot of US companies in these areas. And unfortunately, the US President has said that the tariffs on pharma will be coming very, very soon, and that's worrying. We don't know what to expect there, but obviously it is not good. I think it's important as a government we renew our strategy in terms of foreign direct investment, that we engage very, very actively with the sector, and we send a very strong message to them that we will take a step-by-step approach with them in supporting them through these international economic choppy waters that lay ahead. It's important that we restate and reiterate the attractiveness of Ireland as a location for foreign direct investment. Obviously, our well-educated and capable workforce, our access to EU markets without tariffs, it has to be said, our English-speaking country, and of course a very pro-enterprise government. But above all else, Ceann Comhairle, I think it is critical that we have strong political consensus in this country to face this threat. Together we are stronger. This is an existential threat, and we have to stand together from a political point of view so that we have one voice on this and we face that threat in the strongest possible way. Thank you very much.
Thank you. Deputy Byrne.
Gormagat Lascan Corla, and I agree with colleagues that this is an existential threat to our economy and indeed to society more generally. And it is rather surprising that the party of Eisenhower and Reagan is now led by an individual who is moving towards protectionist policies, which were never part of the Republican tradition in the United States. And I would hope that those who believe in business within the Republican Party might try to convince President Trump of the errors of the actions, because as so many have said, the people who will suffer at the end of this, there are no winners as a result of tariffs. Consumers and businesses around this country and around the world will suffer. So I place great faith in government and in the EU negotiators. And indeed, I wish Maroš Šefčovič, who's very familiar to this country because of his role in the Brexit negotiations, but as the EU's Trade Commissioner, wish him well in the discussions that he will have to lead on behalf of the European Union. And it is critical within these houses that every opportunity is given to ministers to ensure that they are represented at EU decision-making tables, that at no stage should those seats be left empty. So it is critical that when a pair is required for a minister to attend at an EU Council meeting, that would be provided. This will have a significant impact on all businesses, but for small businesses, and many of whom export significantly to the United States, it's going to be particularly difficult. They may not have the individual human resources to address this. Within the programme for government, there is a commitment to establish a small business unit looking at how red tape and so on impacts. I would urge that the Minister in his response might address how that will be set up, with a particular view to making customs as easy as possible. I might also suggest, I think it is important that we explore links with other parts of the world. It's mentioned specifically in the programme for government that we strengthen, for example, our links with Latin America, and that we also talk about the importance of free trade. We as a government have always believed in its importance, but globally and right through history, free trade has always been shown to create more jobs and to lift people out of poverty. That doesn't mean that free trade should not be fair trade, and we always have to have regard to human rights, to environmental standards and to labour standards, but it is critical that we stress how free trade can help all countries and all citizens within those countries. And with that in mind, I would ask, Minister, that a very clear commitment would now be given on the part of government to ratify the Comprehensive Economic Trade Agreement with Canada. Canada has been a very long trading partner with Ireland. It's our 12th biggest trading partner. There are over 15,000 people employed in Ireland by Canadian companies, and Irish companies employ over 6,000 people. To be able to increase free trade between the European Union and Ireland and Canada is something that we should welcome, and it has been growing in recent years. There is a government commitment to do it, but I want a very clear time frame in your response as to when we will ratify the CETA agreement. And then secondly, which is the issue of Ireland's membership of the European Unified Patents Court system, for those inventors and creators to ensure that patents and our intellectual property is recognised and protected right around Europe, that the referendum which was postponed, that would now be held. I believe that it would be appropriate that it should be held in conjunction with the presidential election this autumn, but a clear commitment to that would signal that we do take the issue of patents protection seriously. Other than that, Minister, you know that I think it is important that the entire House will support the government in its actions on this, and that in particular we get as much information out to businesses and citizens as soon as possible.
Lascan Corda, and I welcome the opportunity to discuss the imposition of US tariffs on Ireland and indeed the European Union. Let me start by echoing the Taoiseach. There is no justification for the imposition of these tariffs, none whatsoever. What we're witnessing is not just simply a policy misstep, it's a backward step. These tariffs will hurt businesses, workers, families on both sides of the Atlantic. As someone who represents the constituency of Dunleary, that's home to high-value exporters from fintech to pharmaceutical innovators who ship directly to the United States, I know the harm these tariffs will cause. 80% of our pharma exports to the US are not finished goods. They are critical components in the American supply chains, parts of the global engine that makes healthcare work. And now that engine is being clogged by policy rooted in protectionism, not partnership. And let's be clear, these tariffs won't just land on the ledgers of European exporters. They'll also show up in the monthly budgets of millions of American families. They'll raise the costs of medicine, they'll squeeze small businesses, they'll pause investment, some of which, unfortunately, has already begun. And they threaten to unravel what has long been a success story, the deeply integrated, mutually beneficial EU-US trading relationship. In Ireland and across Europe, we believe in enterprise. We believe in fair trade, and we believe in negotiation. Because that's how responsible nations resolve disputes, not with tariffs, but with dialogue. That's why Ireland strongly supports the EU's readiness to sit down at the table today, tomorrow, whenever the US is ready to talk seriously. But let me also say, while we hope for peace, we prepare and we must prepare for pushback. If negotiations fail, we'll stand with our EU partners in defending our economic interests proportionately, firmly and fairly. Because this isn't just about trade, it's about the kind of world we want to build. One where rules matter, where cooperation triumphs over compulsion, and where shared prosperity remains our common goal. Guramagat Lascam Corla.
Now move on to the Deputy Gibney. Is that right? No, sorry, we're going to Sinn Féin now. Deputy Crowe.
There's no doubt that foreign direct investment has been good to Ireland. The pharmaceutical and medical technology sector in particular has been an enormous boon to the economy, and this has been supplemented in recent years by the tech sector. High-paying jobs and exports allowed Ireland to progress beyond our small island and become a global economy. The reports overnight that the pharma industry is next in the firing line could spell not only disaster for the economy, but those in treatment, both here, across Europe and in the US, who could see drugs become inaccessible through increased costs,